Morning. The Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Campbell, Hall, Lucio, Nelson, Powell, Schwartner, Saffarini, Birdwell, Hughes.
Here. Quorum is present. Good morning, members, and good morning, folks who are participating and watching this morning. We're going to vote on some pending business and then move into the legislation set for today. The chair brings up Senate Bill 275. Senate Bill 275, pending business, Senators. Senator Zaffarini moves that we report Senate Bill 275 favorably to the full Senate with the recommendation that it do pass, be printed. Will the clerk call the roll?
Campbell, Hall, Lucio,
On 275, on SB 275, Senator.
Nelson, Powell, Schwartner, Saffarini, Birdwell, Hughes.
Aye. 8 ayes and 0 nays. Senate Bill 275 will be reported favorably to the full Senate. Senator Zaffarini moves that Senate Bill 275 be recommended and certified for placement on the local and uncontested calendar. Is there objection? Hearing none. So ordered. The chair brings up Senate Bill 162. Senate Bill 162, which we heard last week by Senator Blanco. Senator Zaffarini moves that we adopt the committee substitute, Senate Bill 172. And I'm sorry, 162. That's 162, thanks. Senator Zaffarini moves we adopt the committee substitute to Senate Bill 162. That's the one that Senator Blanco presented to us last week that tightens up the language. If there's no objection, the committee substitute's adopted. Senator Zaffarini moves that we report committee substitute Senate Bill 162 favorably to the full Senate with the recommendation that it do pass, be printed. Will the clerk call the roll?
Campbell, Hall, Lucio, Nelson, Powell, Schwartner, Zaffarini, Birdwell, Hughes.
Aye. There being 6 ayes and 2 nays, the committee substitute Senate Bill 162 will be reported favorably to the full Senate. The chair brings back up Senate Bill 1339. Senator Zaffarini sends up a committee substitute, and the chair recognizes Senator Zaffarini to explain the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute differs from the bill as filed in that it would bracket the bill to Webb County only, and it would clarify that the county submission of a request for an AG's opinion must be approved by the Commissioner's Court. This ties the request to an elected official.
Thank you, Senator. Members, any questions for the author? Senator Zaffarini moves that we adopt the committee substitute that she's just explained to us. Is there any objection? If not, it's so ordered. Senator Zaffarini moves we report the committee substitute to Senate Bill 1339 favorably to the full Senate with the recommendation that it do pass and be printed. Will the clerk call the roll?
Campbell, Hall, Lucio, Nelson, Powell, Schwartner, Zaffarini,
Aye.
Birdwell, Hughes.
Aye. 8-1. There was a short one.
It's local.
There being 7 ayes and 1 nay, committee substitute Senate Bill 1339 will be reported favorably to the full Senate. And that's the pending business we have this morning. Senators, thank you.
Thank you, Mr. Chairman and members.
Okay. I'll pass the gavel to Chair Birdwell and ask if he will take the wheel while I present one bill, and then we have some other very good bills this morning.
Chair brings up Senate Bill 1106 and recognizes the author, Senator Hughes, to explain the bill.
Thank you, Mr. Chairman and members. Under current law, a chiropractor is not authorized to offer expert witness testimony on causation in a malpractice suit concerning chiropractic treatment. In the Civil Practice and Remedies Code, Chapter 74 sets out which health care providers can give expert testimony in a malpractice suit. Of course, the testimony would be on the causal relationship between the claimed injury, harm, or damages, and the alleged departure from the applicable standard of care. Currently, the following folks are authorized. Dentists can offer expert testimony on causation in dental malpractice claims. Podiatrists can offer expert testimony on causation in podiatry malpractice claims. And physicians can offer expert testimony on causation in any type of medical malpractice claim. But the law does not similarly authorize a chiropractor to offer expert testimony on causation in malpractice claims concerning chiropractic care, meaning only a physician can do so. But it's interesting, in a personal injury lawsuit or a workers' compensation claim, chiropractors are authorized to offer expert testimony on causation. So it seems like an inconsistency in the law. So Senate Bill 1106 would address this by authorizing a chiropractor to offer expert testimony on the issue of causation in a chiropractic malpractice lawsuit. This would make sure that both the plaintiff and the defendant and the chiropractor involved in a chiropractic malpractice suit have the ability to call for a chiropractor's opinion on whether something a chiropractor did caused the alleged injury. So this has nothing to do with scope of practice, and it would not enable a chiropractor to testify about a physician's conduct, but a chiropractor could testify as an expert about a chiropractor's deviation from the standard of care in a chiropractic malpractice case. That's what the bill does. I have more detail out, but I'll spare you unless you have questions. I'll yield.
Members' questions? Senator Lucio.
So you're just trying to change what's already happening in terms of medical doctors being the sole experts that lawyers go to, let's say, to get the medical support that they need to make sure that their client's, situation is one that can be addressed by chiropractors, which is not done today. Is that correct?
Senator, that's correct, and this would only apply in a case where someone is suing a chiropractor. They're claiming that the chiropractor didn't follow the standard of care. So this is only in a case against a chiropractor. It would allow a chiropractor to be an expert on chiropractic standard of care.
Okay, thank you.
Well, thank you, Senator.
Okay. Members, other questions of Senator Hughes? All right, we'll move to invited testimony, followed by public testimony. Chair calls Dr. Thomas Hollingsworth. Dr. Hollingsworth, if you would join us. And then on deck, I only have one public witness registered, a Michelle Quattlebaum. Michelle, if you'd make your way down, if you were here, if you would. And that is all I have registered for this bill. So if you are not registered but wish to testify, if you would make your way down, I would greatly appreciate it. Dr. Hollingsworth, as invited testimony, you have 5 minutes. If you would, state your name, whom you represent. Welcome, and you have 5 minutes. Thank you, sir.
Thank you, Senator. My name is Dr. Tom Hollingsworth of Corpus Christi. I'm a doctor of chiropractic, and I practice in Corpus Christi, Texas. I'm representing myself as well as the Texas Chiropractic Association, on which I serve on the board of directors. This bill came to my attention, or the concerns for this bill came to my attention as I was asked to render an opinion on a chiropractic malpractice case. And given that I was beginning my foray into these expert witness opinions, I was shocked to find that I could not give an opinion on whether a chiropractor could give an opinion on whether the doctor caused the injury that was alleged. I could render an opinion on standard of care, but I could not render an opinion on whether I believe injury causation was involved. And so I sought to change this. Right now, doctors of chiropractic are recognized by the state to render opinions on causation of injury in work comp cases. We can do impairment ratings. We can give these kinds of opinions in personal injury cases, and so it only makes sense that we're also able to do this in a case that involves a chiropractor accused of malpractice. To be clear, one of the things that I heard earlier, we're only going to be testifying when a chiropractor is alleged to have committed malpractice. Right now, there are portions of the law that allow a podiatrist to render an opinion on a podiatry case. It allows a dentist to render an opinion on a dental case, and we're just seeking to add chiropractors to that. But I will not be rendering opinion on dental cases. I will not be rendering opinions on podiatry cases or anything like that.
Thank you. Members, questions for Dr. Hollingsworth? Senator Schwartner, you're recognized.
Yes, thank you. Could you please give the scope of practice for a chiropractor in the state of Texas? What y'all are able to treat per law?
It's been a while since I've looked at the Chiropractic Act. I believe that it says that we can use subjective and objective means to diagnose, assess, evaluate the biomechanical condition of the spine and musculoskeletal system, and that we can use non-surgical and non-incisive means to improve the subluxation complex and the biomechanical condition of the musculoskeletal system. And then it goes on from there, but I'm guessing that's what you're asking?
Yes, that's pretty good.
So you already knew the
synopsis
answer?
What's that?
So you already knew the answer?
Yes, I did. So it's fairly limited to the spine and the
In the subluxation complex.
subluxations of the spine. The bill as written appears to allow the chiropractor.
I'm sorry?
The bill as written appears to allow a chiropractor to provide expert testimony on the causal relationship between injury, harm, or damage claimed. And so that injury, harm, or damage can be significantly different than just something relating to the spine or the subluxations of the spine. For instance, would a chiropractor be an expert, an individual that is qualified to be an expert in for instance, a misdiagnosis that was treated chiropractically for a while that was not within the purview or scope of that chiropractor to diagnose, but they missed it and treated it for quite some time before it was properly diagnosed? Who should give an expert testimony in that type of situation? For instance, a tumor in the brain, for instance, causing back pain or neck pain or
A tumor in the brain that is causing what?
A tumor in the brain or spine that causes a neurologic deficit that is treated as a subluxation, but is actually a misdiagnosis for weeks or even months. Who should be able to give an expert testimony in that type of situation?
In that regard, that would almost, in my opinion, of course, that and 50 cents might buy you a Coke and an old Coke machine. But in that regard, that would not necessarily just be causation, but that would also fall under what we can already testify on with standard of care. Because our standard of care under the board rules, under the administration code, requires a timely referral for those things that are outside of our scope. And so I'm going to say that we can already testify to that.
Yeah, maybe. I'm not for sure about that. But again, the bill as written would allow for a testimony regarding the causal relationship between that injury, in this case, a tumor in the spine that was a failure to diagnose, and the harm and damages associated with that by a chiropractor relative to a medical doctor who has an unlimited license to practice medicine and surgery in the state.
And this does not limit the physician scope by any stretch. It just adds chiropractors to be able to do that, just as dentists and podiatrists do. Neither dentist nor podiatrist have your scope as well in the practice of medicine.
Would you think a chiropractor giving expert testimony would be more friendly to a chiropractor that is in a certain type of suit versus a medical doctor that is An expert in that?
An expert witness can serve for either the plaintiff or the defendant.
All right. All right, I'll look at that bill more. Thank you very much.
Members, other questions for Dr. Hollingsworth? All right. Thank you for joining us this morning, sir.
Thank you.
Chair calls Michelle Quattlebaum. Michelle, did I remotely pronounce that correctly?
You did.
Okay, good deal. If you would, please state your name.
My name is Michelle Quattlebaum.
And whom you represent. And
I represent myself.
Hold on. Let me.
Sorry.
And as public witness, invited testimony gets 5 minutes, but as public testimony gets 2 minutes. So state your name, whom you for the record.
Okay.
State your name, whom you represent.
My name is
2
Michelle
minutes. Thank you, ma'am.
Quattlebaum. Excuse me. I am a board-certified trial lawyer, and I specialize in medical malpractice, medical doctors, dentists, chiropractors. I also have an honorary chiropractic degree, which was awarded to me by the college. Okay, this bill, and thank you for considering it, 1106, it is very special to me because I deal with this on a practical basis for 40 years. But in 2003, when the Healthcare Liability Act was codified into Chapter 74, I think it was an error or just a mistake that they did not add a third paragraph to the experts. Dentists can testify as to dental malpractice causation, podiatrists can, but you turn the page and went, oh my God, they forgot the chiropractors, because chiropractors were added in 2003. So what this technically does is, all this bill does, and I was listening to the questions to Dr. Hollingsworth, it's not about standard of care, it's about causation of chiropractic care. So right now, I cannot present an expert who has maybe 30, 40 years of chiropractic, written textbooks, taught the school, taught biomechanics, to testify about a chiropractic adjustment and what it might cause, just as the dentist or podiatrist or anyone can. It does not take away from the medical community. It does not take away from physicians' testimony, but it does add that the best person to help the fact finder, a jury, to know what a chiropractic adjustment can and cannot do by the people who are more trained. It doesn't take us outside the scope. It doesn't add to brain tumors or anything. What it talks about is chiropractic adjustments and what can and cannot be, what in his opinion can be done. Okay. And I could talk for hours, and I apologize, but thank you all so much. And but I would like to answer any questions.
Members, questions for Ms. Quattlebaum? All right, thank you for joining. Oh, okay. I'm sorry, Senator Lucio, please stay, man. Senator Lucio, you have a question?
Obviously, this bill is important to some people, or else it wouldn't be on the table. I want to make sure that we're not taking up a bill that, for some reason, the chiropractor has misdiagnosed an injury and tried to fix it and worsen it, and then gets sued. And this bill, in some way, impacts that lawsuit. What is this bill ultimately going to do to anyone out there that is misdiagnosed, who didn't go to a medical doctor but went to a chiropractor? And I really respect chiropractors, I really do, but I'm just wondering where we go from here if once this bill is voted, and approved and becomes law. Will it in any way impact someone from being able to seek remedies at the courthouse? I'm not an attorney. I'm just thinking outside the box.
I think that's a great question, and it doesn't impact that at all. Access to the courts against chiropractors or dentists or speech pathologist or anything. None of that is changed by testimony about causation. Standard of care is still in place. That is not an issue in this bill. This bill just takes whether a person, that a chiropractor, because he doesn't have, or she doesn't have physician status, that they should still be allowed to testify about their care and to testify about the biomechanics or the effect. It does not, but as far as I do have, I've been practicing this month, next month will be 40 years, and this is what I specialize in. Unfortunately, there's not that, for financially, there's not that many chiropractic malpractice cases because there are very few injuries that are caused. But I do all the different specialties. But this is, with misdiagnosis, that's the standard of care. They're already allowed to testify, obviously, about the standard of care. But this just takes it into the other realm, because in a lawsuit, you talk about standard of care first. And if they breached that standard of care, if they fail to diagnose something, which is actually, there's very, very few lawsuits about that. But if they breach the standard of care, say, for failure to diagnose, then it goes on to the second step in a lawsuit. Then you must prove, well, there's two other steps, but first, that it caused an injury, that diagnosis caused an injury, and then whether there's actual damages. So what's the problem that we have had since this was codified in 2003 with the Civil Practice and Remedies Code, that it has taken away the person or the people who actually know their treatments the best, the people who've been trained in it, to explain what especially chiropractic adjustment can cause or can't cause. That's all. The medical doctors are still allowed to testify as to their opinions. Anyone else, it just adds, because it gives the chiropractor, only in chiropractic malpractice cases, the right to testify about causation of their care. And then still the courts would deem, if these are experts, they would deem if it's relevant testimony. As far as prejudicial, there are a lot of chiropractors who testify against other chiropractors. I think they're giving honest testimony because that would happen. It's just that the reason this has gone on for 18 years unchecked is it really hasn't been a big bell ringer because there haven't been a lot of lawsuits, but when there are, and I face it right now personally, I mean, I'm defending cases currently where the people who know the most can't testify, and that's all it's doing. It's not giving
Thank you.
anything. Thank you. Yes, sir.
Thank you, ma'am. Members, any other questions for Senator Spertner? You're recognized.
So what I'm trying to understand in the bill is will allow chiropractors to testify regarding causation relative to failure to diagnose cases.
Well, but if failing to diagnose, so if the failure to diagnose caused an injury, so for instance, if they didn't take an x-ray properly, and so therefore they missed a fracture, and they treated that fracture, yes, they would be allowed to say, if you have an active fracture, an acute fracture that's not healed, you should not adjust it. So that's standard of care. But did that adjustment cause a displaced fracture? It's my understanding you're a medical doctor, so you understand. I may not be. Okay, so it would cause a displaced fracture. Yes, they could say, yes, this adjustment should not be done. That's standard care. And could it cause it? Yes, it could, because of what an adjustment would do to an acute fracture. So yes, they could do that. I don't think that's outside their standard of care. We're not talking about, they still wouldn't be testifying about matters outside their scope. We're talking, this is just in a chiropractic malpractice case where they're accusing that doctor of causing something with his care. This isn't opening it up to other types of lawsuits or other types of situations, administrative situations. This is talking about chiropractic malpractice cases when they're alleging that a treatment caused an injury, and so therefore that a chiropractor should be allowed to testify as to what his care is. Right now, I have people are qualified because they're physicians, and they're good physicians as far as orthopedic surgeons. They know nothing about what an adjustment is. And they can't because it's not their scope, it's not their training. But yet, just because they're physicians, the wording of the statute is what needs to be changed. And it just gives them the same right that y'all have given to the dentist and the podiatrist, and which would be, because it's different, it's a different situation.
So regarding the defense of causation claims, it would also allow a chiropractor to testify on behalf of the defendant chiropractor regarding that individual did meet the standard of care despite a fracture or a misdiagnosis, a tumor in the spine or something like that, regarding the claim being defended against. So it's not just they'd be able to say that they had met the standard of care in certain claims as well in the defense aspect. So not just on the plaintiff side, but also on the defense side.
Yeah, if I understand your question, I apologize. Well, standard of care and causation are two different, they're two different, completely different steps in a lawsuit. And so right now, standard of care, it's anyone that's trained and experienced that can meet their expert, a judge considers an expert, so standard of care. Then the causation comes second. So you have to link them to recover in a lawsuit. But this would allow the people who are trained and experienced and actually perform these adjustments to be allowed to give their opinion as to whether or not that caused an injury. So it's just the same as, I do med mal and all too, and that those same steps appear, but it's very prejudicial the way it's written out. It's in a lawsuit right now that the people most knowledgeable aren't allowed to testify.
Okay, I appreciate your answer.
Yes, sir, thank you.
Members, other questions for Dr. Waddlebaum? All right. Thank you for joining us.
Thank
today,
you
ma'am.
so much. I
Thank
appreciate it.
you. Is there anyone else wishing to testify on, for, or against Senate Bill 1106? All right. Hearing and seeing none, public testimony is closed. We'll leave the bill pending. We'll now move to Senator Buckingham's bills. Chair lays out House Bill 2536 and recognizes the sponsor, Senator Buckingham, to explain the bill.
Thank you, Mr. Chairman and members, for allowing me to bring before you House Bill 2536, which adds due process protections for families with medically complex children. The bill passed out of the House committee and floor unanimously and without any amendments, particularly because it is very short and a very clean bill. The Family Code, Section 161.001, currently enumerates several behaviors which, on their own, cannot be used as grounds for termination of parental rights. These include things like being economically disadvantaged and being homeschooled. This bill merely adds that seeking an opinion from more than one medical provider, transfer of the child's medical care to a new provider or facility cannot, in and of itself, be grounds for removal of a child from its parents. This bill would help protect Texas families, and especially those Texas families with medically fragile children, by amending current Texas law to describe actions commonly taken by loving and involved parents who care deeply about their child's medical care and helping ensure that those actions cannot be used as a basis for accusing a parent of abuse or neglect or to otherwise interfere in the parent-child relationship. Thank you, and I'm happy to answer any questions.
Members, we do have a resource witness, Martha Talbert with the Department of Family Protective Services is available. Anyone have any questions for the DFPS? Senator Hall, you have a question for our resource witness? Okay, hold on. Let me, does anyone have any requests for resource witness? All right. Questions of the author. Senator Hall, you're recognized.
It's much a comment as it is a question. I think this is a very good bill, having had a great deal of personal experience in a case that's referenced in here, the Pardo family, which was highly abused by the system that existed at the time. This is a long overdue change, overhaul that's needed, and I think the commissioner will welcome this change to give her the tools she needs so that this kind of abuse that's happened in the past will not continue. So thank you for carrying this, and I'll be glad to join with you on this bill.
Thank you, Senator Hall.
All right. Members, other questions for Senator Buckingham? All right. Thank you. We will move to public testimony. Chair calls Jeremy Newman, and on deck, Cecilia Wood. Those are the only two members that I have, or those only two registered witnesses that I have. If there's anyone else that wishes to testify on HB 2536, please make your way down to the to our on-deck area. Again, Chair calls Jeremy Newman and Cecilia Wood. Just registered for, but not all right. Is there anyone else wishing to testify on, for, or against HB 2536? All right. Hearing and seeing none, we will close public testimony and leave the bill pending. Senator Miles has just the one bill. Can I go to Miles? Okay. Senator Miles, you just have the one bill, if I may. Senator Buckingham, if I may, let me get Senator Miles taken care of, then I'll come back to you for your other two bills. Chair lays out SCR 29 by Senator Miles, recognizes the author to explain the bill.
Thank you, Mr. Chairman, committee members, for allowing me the opportunity to lay out Senate Concurrent Resolution 29. 20 years ago, some other committee meeting, sorry, Mr. Chairman. 20 years ago, the 72nd legislative session passed HB 1756, sponsored by then State Senator Rodney Ellis, my predecessor. HB 1756 directed TxDOT to submit name change applications to the United States Board of Geographic Names on almost 20 geographic features in Texas, all containing the word Negro. The names included Negro Hollow, Negro Tank, Negro Head Lake, amongst others, all similarly prefaced with the word Negro. However, the Board of Geographic Names requires name changes to include local support in the form of a formal resolution by local county commissioner boards or city council to clear support of a new name. Thus, the changes these names eventually languished and was never accomplished in 20 years. However, the United States Board of Geographic Names is waiting for its next meeting this June to finally change these names, Mr. Chairman. Furthermore, as part of the most recent review, HB 1756 mandates the United States Board of Geographic Names to identify additional geographic features offensively named with the word Negro. Local communities must initiate the process with the Board of Geographic Names. SCR 29 simply implores these names are changed for the good of Texas. Mr. Chairman, I ask that you and your committee take this bill very seriously, and we take action on this bill.
Okay. Thank you. Members, questions of Senator Miles? All right.
I think I provided a list with all of the
Thank you.
all of the over 30 locations in the state of Texas that have sites with the word Negro in them.
Okay. Thank you, Senator Miles.
I've got two witnesses.
We have invited testimony. Mr. Richard Wade, and on deck, Gary Bledsoe.
Gary Bledsoe is his name, sir.
Say again, Senator Miles?
Gary Bledsoe with NAACP.
Right, he and Mr. Wade are the invited testimony, and then I have one individual for public testimony, David Wiley. So, Mr. Wade, if you would, invited testimony has 5 minutes, If you would, state your name, whom you represent, and give us your testimony. When the light turns yellow, you have a minute remaining.
Thank you, Chairman Hughes, Vice Chairman Birdwell, and members of the committee. I appreciate you inviting me to give my remarks this morning. For the record, my name is Richard Wade. I'm the Deputy Executive Administrator at the Texas Water Development Board. I serve as a State Geographic Information Officer, as well as I chair the Texas Geographic Names Committee, where I'm one of 6 on that committee. The Texas Geographic Names Committee serves as an advisory role to the United States Geographic Names Board, a role that is an impartial viewer or reviewer for the information that is given back to the USBGN. We approve and we review and we approve whether the names are accepted or not, but the final decision is with the USBGN. Over the last 5 months, we have been working with representatives at the USGS, U.S. Bureau of Geographic Names, along with Harris Commissioner Rodney Ellis, State Representative Ron Reynolds, Bay City's Councilmember Charles Johnson, and individuals of the TxDOT team. We needed to understand what was going on with the names and how come they didn't get accepted the first time. And it turned out that it wasn't an issue with the names being changed, it was what they were being changed to. From what we understood is that House Bill 1756, as mentioned by Senator Miles, actually had names that weren't necessarily provided by the locals or were actually supported by the local community. However, when we were working with them, with the USBGN, the original 17 names, they did agree to take it up at the June meeting that's coming up here in the next couple of weeks. The names were considered to be after about 20 years, they realized that enough time has gone by that they're going to run it through the process. So with that, they actually did a deep dive back into the database and discovered 11 more names. What I really would like to reiterate here is that removing racially insensitive and derogatory names is probably the best reason to make a name change. The request of the BGN of the original 17 names were all supported, but because there wasn't enough local and maybe a local support for the names they were being changed to, it was determined that they were holding off until they could get that support. We realized that over time, this took way too much time. So the BGN has a very strict and stringent process for changing names, which is put in place by design. It's made so that we can properly vet the names. Once we want to make that name sure that it has the backing of the local community once before the names actually get changed. They feel it's extremely important that they say that they know what the new names are and that the local community actually has full support. A normal name change can take anywhere between 8 months and 18 months. From start to finish, and this is to accommodate the entire process. A lot of hearings have to go on, and a lot of people have to review it before it moves forward. In closing, I would like to state that the Texas Geographic Names Committee is completely supportive of changing these names. These names, we look forward to the ability when these names come to our desk and we can review them and make a recommendation back to the board. What we do feel that if counties could be consulted early in the process and perhaps even drive the process, this would make the process much smoother in the future and much quicker as well. So with that, I appreciate you letting me have a few minutes to talk to you today and want to thank specifically Senator Miles for supporting this resolution. And that concludes my prepared remarks, and I'm happy to take any questions.
Senators, questions of Mr. Wade? All right. Thank you for joining us today, sir. I appreciate it. Thank you. Chair calls Gary Bledsoe. And if you would, Mr. Bledsoe, please join us. State your name, whom you represent. You have 5 minutes. No, I think, Mr. Bledsoe, you've been with us before, so you know that when the light turns yellow, you got a minute left. So thank you for joining us. You're recognized.
Mr. Chairman, members of the committee, I want to thank all of you so much for hearing this bill, and I want to thank Senator Miles for sponsoring it. I'm one of the individuals that originally brought the bill before the legislature back in 1991, so I looked a little younger when I was here back then. I was one of those who supported the bill way back in 1991 when I saw we had places named with the N-word and saw one with my own eyes. I was shocked and horrified and asked our General Land Office to investigate. They found about 31 names in Texas. We then found that President Kennedy changed the name to Negro, but that was not sufficient in our minds. For example, one near Austin was called Negro Head Mountain. I found this to be offensive. These names were put there in order to offend and denigrate African Americans. Sadly, we saw so many other groups are the subject of offensive names in Texas and throughout the nation. The use of the term Negro in the context it has been used on Texas places covered by this legislation has no basis in an orderly, democratic, and pluralistic society. It can only divide us and make us weak. We must make a statement that official names based on race as these are completely appropriate. What SCR 29 does is it lets the federal government know we do not agree with its decision not to change the names on places in Texas selected by the Texas legislature that were adopted by an overwhelmingly favorable bipartisan vote of both bodies of the Texas legislature. Using Negro instead of the N-word does not change our position. Each and every one of these names adopted by the legislature in 1991 were researched and duly connected to our state. Recently, I had a conversation with a talented young lady who is the president of the Thurgood Marshall School of Law Student Bar Association at Texas Southern University, who grew up next to Negro Lake in Baytown. And she told me that even as a young girl, how she was offended and asked her mom questions about why the lake had such a name. She said it was humiliating. She is of a different generation from me, but she feels the same as I do. Such names say you are not respected and that in many ways you do not belong. They do not invest you with the kind of shared stake and ownership of our governmental units we want our citizens to have. Having humiliating place names only serves to divide us and pit Texans against Texans. This is what we want to avoid. The names of our places mean something. We must and should become one Texas. We ask you to stand up for all senators and support SCR 29. Thank you very much.
Thank you, Mr. Bledsoe. Members, questions for Mr. Bledsoe? Senator Lucio, you're recognized.
Thank you. And President Bledsoe, thank you very much for being with us here today.
Thank you, Senator.
And participating.
Great to see you.
It's always very meaningful. It's always a pleasure to hear you, and I've seen you for a few decades now, being a great leader in this state and this country. So
that's mutual, Senator. Thank you.
I'm very pleased with one of our newest members on the floor, Senator Miles, has also brought that leadership to this floor, and hopefully we can see a better day than those dark days that we've seen in the last few years, unfortunately, in our country, where we can all respect one another and care for one another, be understanding of one another, and do whatever is needed to make this country whole. Thank you.
Thanks, sir. You've been such a great voice for that, always reaching and having such a broad array of arms, and I know how greatly you've represented the people of our state, and I appreciate working with you and look forward to working with you on this bill.
Thank you, sir.
Thank you.
Thank you, members. Other questions? Senator Powell.
Mr. Bledsoe, would you speak to that argument that always gets made that this will diminish our monuments and markers across the state of Texas?
Senator, thank you so much. I think that's a great question. It will not, this bill won't diminish them in any way. I do think, though, that in terms of there are other bills pending in reference to that. I know that Representative Anchia has a bill over in the House that does that. And I've always felt, and I mean no disrespect to anyone, that we should be about the United States of America. And there's so many people from Texas who fought with valor in many wars who have not been honored. And we should give honor to them first above those who might have taken up arms against the government of the United States of America. This bill simply goes after the offensive names that relate to African Americans. However, the sad thing is when we did a survey, Senator, and looked to see, there were many of other offensive names against other groups. So there were offensive names relating to women, relating to Asians and Latinos and Mexican Americans in this state, and we really shouldn't have that. We should be about being, again, one Texas, where everybody can feel invested in the same way with a stake in who we are and where we go. So there are many more, and I would hope at some point we'll be here talking about eliminating those names as well.
Thank you, Mr. Bledsoe. I'm grateful for your testimony today.
Thank you, Senator. Thank you.
Thank you. Members, other questions from Mr. Bledsoe? All right. Thank you for joining us today. Have you seen the, I've not seen it, but the new World War I memorial in Washington, D.C. that was just dedicated a couple of days ago, that particularly when you look at the desegregated military didn't occur until the Truman administration, but African Americans played a significant part in World War I, and so yeah.
Absolutely, and one and two, many fought in one. Ironically, many African Americans had to fight under the French flag because of discrimination, but they fought with valor, and indeed the French government honored them with a monument that was there in Paris that was bowled, one of the first ones bowled over by Hitler when he overran Paris. But there's a great history there with Texans also. In World War II, we know that Doris Miller and the big efforts to get him the Congressional Medal of Honor that he so rightly deserves.
Yeah. Yeah, unfortunately, Doris didn't survive the war, but we have a bridge in Waco named after him because that's where he came from. So
absolutely, Congresswoman Johnson has really been vigilant on that and trying to make sure that he gets his proper due at some point.
Yeah. Thank you for joining us, Mr. Bledsoe. We appreciate it.
Thank you. Thank you all for
having me. Very much. Chair calls, we'll move to public testimony. Chair calls David Wiley. Mr. Wiley, if you would, please join us. Public testimony has 2 minutes. If you would, Mr. Wiley, state your name, whom you represent, and you have 2 minutes. When the light turns yellow, you have a minute remaining.
Thank you very much, Chairman Birdwell. I'm David Wiley. I'm a member of the State Republican Executive Committee of the Republican Party of Texas from Senate District 12, and I live in Argyle, Texas. I am representing the Republican Party of Texas, and I'm speaking in opposition to SCR 29 today. This past spring, over 97% of the voters in the Republican primary of Texas voted to protect the monuments and markers in our state and protect them from being changed or dishonored. This past summer, almost 8,000 delegates met virtually at the state convention of the Republican Party of Texas, and these delegates heard testimony on the issues facing Texas and voted to support legislation that protects and works against legislation that dishonors or changes our monuments and markers is one of the most important legislative priorities of all issues facing Texans. SCR 29 will help tear away those things that have been named for people, events, and simply the history of what Texas is. Changing the names of things to something that's more socially acceptable at the moment only serves to lessen the importance of the name in the first place. We need our monuments and markers to remain as they are in place and in name. And please do not approve this resolution. I thank you for your time, and I'm available to answer any questions.
Senator Hughes, you're recognized.
Thank you, Mr. Chairman. Mr. Wiley, thank you for being here. And I know that work on the executive committee is a lot of work, and it pays even less than what we get paid. So thank you for doing it. And the discussion about our monuments and markers is an important one, and which we'll continue to have. And I think you and I agree on that. This bill, it may not be clear from the wording of the bill, but I want to make sure we're clear. This bill will only apply. This is not about markers or monuments or anything like that, or about people. This only applies to those geographic places that had the N word in their title. It was a slang term, and it was changed to a little bit less offensive term. But I'm not fussing at you, but I want to make sure we're clear, because sometimes information comes out at the hearing and it wasn't clear, from the language of the bill. But I want to certify to you that the only thing this bill has to do with is those geographic locations. I'm going to let you respond. I want to make sure we're clear, because sometimes it's kind of fuzzy. This is only about those particular geographic locations. It's not about history or people or individuals. So I know there's a larger discussion about that, but I want to be clear. This is not. And as someone, and I'm going to say, as someone who participated in that convention, when we voted on monuments, we did not talk about places with this word in their name. So I just want to make sure that's clear, because it might have been kind of fuzzy from the language of the bill. Do you see what I'm talking about?
I do totally understand, and I mean no disrespect to the senator or the gentleman who spoke before me, even though it could be taken as such. I sincerely do not mean a disrespect. Our position is that 30 years ago, when the legislature first addressed this issue, since that time, the communities that have had these locations named as such have had the opportunity to participate in the naming of them, in the renaming of them. And we're trying to revisit that from the way I understand this. If those communities have not stood up to get these name changes applied, then obviously, in my opinion, these are important to them. And again, I mean no disrespect. We did hear testimony that this is perhaps just the first level, and it's a slippery slope. Once we do this, then there are many others perhaps to go with.
No, I understand it, and I don't want you to think I'm fussing at you, but I want to make sure we were clear on what this bill does, because this bill is very focused. It's not about monuments or about history. This is just about particular offensive names. And when the legislature passed that, I don't think there's anything in the record that suggests the local communities have come out and said, we like these names, but the feds, the USGS, need something more official from the legislature. Again, I'm not arguing with you, but I want to make sure that the record's clear. This is not about monuments or history. This is about particular places where offensive names have not been able to be removed because of a technicality. This is really something you and I can relate to. This is about making the feds do what we have asked them to do in Texas. That's really
we
what
like that every time it's tried. Yes.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Senator Lucio, you're recognized.
Thank you, Mr. Chairman. I just want you to know one thing, that I take pride, and I use that word pride, in working with both sides of the aisle on this floor to address issues that members bring to the table, who they feel, issues that they feel we need to address to stop the hatred, stop the hate that goes with name calling. And I will do anything to bring us together and show respect for whatever it is that we need to do to form a more perfect state and a more perfect country when it comes to respecting ethnicity and culture and tradition and all of that. But name calling goes beyond what. And I felt it in the 60s. I saw it as a college kid. And I don't want to see those days come back. I think what is being asked for in this SCR is really something that's most important to the African American community. It's important to me as a Texan, as an American. And I would hate for us not to come together bipartisanly to agree that all things are not perfect. And when it comes to name calling and subduing somehow someone's background and culture and allowing words that we're not proud of to continue to be part of our history is not the right thing to do. That's all I'm saying here. You have the right to be here. You have the right to voice your concern. But Senator Miles has his right to. I do. Senator Safrini, the chair, was so elegant in explaining to you what this really is all about. Not about changing monuments or doing anything else. It's by making sure that the name calling stops and that we respect one another as human beings and that we respect one another as Americans first under God. This nation is such a great nation, and whether we're born here or we came here, and many generations ago, my people came here from Italy, and they weren't very nice to them in New York and other places. There was this discrimination has to stop at one point. When you stop that, you stop hatred, and we become whole. I'm not saying you're here advocating discrimination or hatred. I'm just saying look at it carefully and look at what Senator Miles is trying to do here, trying to bring us actually together and get ourselves thinking as one Texas family, one American family. That's all it is. Thank you, Mr. Chairman.
Thank you, Senator Lucio. Senator Miles, and then we'll come to Senator Zeffrini. Senator Miles is recognized.
Thank you, Chairman Birdwell. I simply want to take this moment to answer the question that Chairman Hughes asked. Yes, this bill simply relates to locations. It does not relate to any monuments, any statutes, or anything of that nature. It simply relates to geographical locations that have the word Negro in it. So I wanted to make sure that I answered that question for you directly, okay? And you're right. We are simply trying to instruct the federal government of something that the state of Texas agreed to in 1999, that this body agreed to in 1999. And in 20 years, they have not done it. It's no different from us telling the federal government on other things that we want or don't want here in Texas. We want this one. We voted for it. We passed it. And we're just trying to get it 20 years later. And as it relates to Senator Lucio, you're absolutely correct. You know, colleagues, I've been in many conversations that talk about reparations for African Americans. And in my conversations about reparations, I always interject. It's not reparations that we need to bring our country together. It's reconciliation. It's reconciliation for the African American community and what happened to them in this country. It's reconciliation for the Hispanic or Latinx nowadays for what happened to them in this country. It's reconciliation for the Asian community, what happened to them in this country. And until we can reconciliate, we're going to continue to have times and atmospheres like we have right now that are tearing our country apart. So Senator Birdwell, the military man that you are, I know that you know that our strength is in our numbers and our diversity. But until we can reconciliate, it's going to be hard for us to get there. Thank you, Mr. Chairman. Thank you, Vice Chairman. And it was in 1991, 1991, not 99. And you were here, Senator Lucio. Thank you.
Senator Zeffrini, you're recognized.
Thank you, Mr. Chairman. Sir, I'm looking at your written testimony and, of course, listen carefully to what you said and to what my colleagues on the committee said. But your written testimony says that you represent the SREC and the Republican Party of Texas. But then when you mentioned the votes in the Republican primary, 97%, and the votes of the 8,000 delegates who met virtually at the state convention, you also mentioned that they voted on the issue of monuments and markers in both cases. So I'm wondering if we really are talking about two different things, because your concluding statement is also, we need our monuments and markers to remain as they are in place and in name. But having listened to our colleagues on the Senate committee, would you agree that you're talking about two different things? You all voted for monuments and markers, but this is about geographic names. They're two different things.
I do agree that there are some differences between what is perceived as monuments and markers and these very specific items. These very specific items are certainly not something that we're saying we should leave alone. But it is the movement on the part of the state to change the names of the places, the markers, the history marking of things in Texas that we felt as though on the part of the Legislative Priorities Committee of the Republican Party did cause us to come and have a discussion about not changing names simply because they are racially offensive. If a community wants to change a name, then they choose the names for their own areas and items. I definitely don't want to get into being in the position of saying that I like those things. But if we were to review all of the names, as was said earlier, in Texas, and say that we can only have neutral names that don't have to do with anybody, then we begin to get to the place where it does impact the markers and monuments in Texas.
Thank you. But your oral and written testimony indicate that you represent the SREC and the Republican Party of Texas, but in fact, neither body, neither the delegates nor the members of the SREC took action specifically against SCR 29. Is that correct?
I am a member of the executive committee of the State Republican Executive Committee of the Republican Party of Texas. They are the same. And I am on the legislative priorities as a subcommittee chair for the Monument Protection Legislative Priority. And it's the opinion of that committee that SCR 29 will move forward in changing names of other markers and monuments. And we wanted to have this input to this, and I do respect the other side, and I thank you for your point.
Thank you. Thank you, Mr. Chairman.
Senator Powell, you're recognized.
Mr. Wiley, with all due respect, I take exception to the slippery slope conversation. I believe you were in here to hear Mr. Bledsoe testify specifically about a lake named Negro Lake, where a young lady who has been elected as the president of the Thurgood Marshall School of Law Student Bar Association has to look at that name every day. And we've heard about other geographic locations that have names like Negro Head Mountain. And do I understand you to say in this chamber that you believe that this young lady who's the president of the Thurgood Marshall School of Law Student Bar Association should have to be subjected to that kind of discriminatory name on that lake every day because it's a slippery slope with regard to monuments and markers?
I do not believe that anybody should ever be have to be put through discomfort or humiliation or any of those things. The names of places and markers and the like come from those in the areas. I do not know what went into the original naming of those markers by the people in those areas. If something is truly offensive, and I apologize that John F. Kennedy, acted in such an insensitive way, is to change it to what he felt would be more sensitive from what was absolutely horrendous. But in the same way, 30 years from now, what are people going to say about what we are doing today? Who are we to say that we are so much more enlightened than John F. Kennedy was in his time? And, working to just try to make it better at this point in time.
Is irrelevant?
It's not irrelevant, but I think that those communities in those areas where this young lady lives should be able to determine the names of the areas that they have. It should not be imposed upon them.
Would you agree that times change and that mankind changes and that there is an absolute necessity for us to grow from that change?
Certainly, and I think that our society today is very representative of change over time. From the time that I was a young man growing up in what still was a segregated Arlington, Texas, and I went to the schools on the east side of town, whereas the place that they sent the children from Tarrant County, Grand Prairie, to go to school. Growing up in a 95% black school, I understand that there is much difference today over what there was 40, 50 years ago when I was coming through.
Well, I would argue with you that that's true, but I would also argue that the statement in your testimony today, it doesn't match that thought process. I thank you for testifying.
Members, other questions of Senator Miles?
As we close this conversation out, Mr. Chairman, I want to make it very clear. The witness stated that they had conversation about this particular bill. This bill, nowhere in this bill does it mention anything about a statute or a monument. They said they had conversation about locations. If I heard him correctly, is that correct?
Yes, sir.
Conversation. Members, our body 20 years ago upheld this bill and asked the federal government to do this 20 years ago. Are we going to now start allowing people to come in and redo things that we have supported, passed on over 20 years ago on a simple conversation? Is that what we're coming to as a body? That we can allow somebody to walk in our doors after we've all agreed on something over 20 years ago and change something? Is that what we're coming to? That would be the question that I leave with you. Again, no monuments, no statutes, just names of locations. If my son asked me to go to whatever city Negro Head Mountain is in, what am I going to tell him? Yeah, we're going to Conroe to see Negro Head Mountain. He's born and raised in the state of Texas. So am I. We're just as part of the fabric of Texas as anyone else. I strongly urge and ask that you support SCR 29 and that we bring some kind of reconciliation in some kind of way to the citizens of the state of Texas, and we can not continue to go down this path of hatred.
Thank you, Senator Miles. Thank you for joining us today, Mr. Wiley. Thank you.
Thank you very much.
Is there anyone else wishing to testify on, for, or against Senate Concurrent Resolution 29? Hearing and seeing none, public testimony is closed. Mr. Chairman, do you still want me to retain the gavel? I'm going to pull Senator Buckingham back
Thank you,
up.
members.
I do have a question for on one of her bills. So, but I don't know if you. Okay. Then let me return the gavel back to you, Mr. Chairman. We already did 2536.
Welcome back, Senator Buckingham.
Thank you, Mr.
The chair now lays out Senate Bill 912 and recognizes its author, Senator Buckingham, to explain the measure.
Thank you, Mr. Chairman and members. Senate Bill 912 seeks to deter violent rioters from harming first responders and guarantee restitution to property owners that incurred damages as a result of riots. The riots that took place last summer started as constitutionally protected protests, but in some cases turned violent and destructive. The riot statute, as currently written, does not go far enough in deterring rioters from harming first responders and property. This bill would increase the level of what these perpetrators could be held accountable to by increasing the criminal penalty from a Class B misdemeanor to a state jail felony in certain cases. This is triggered when the actor, while participating in the riot, 1, knowingly committed or attempted to commit an assault against another person, or 2, against a person the actor knew was the first responder while the person was performing his or her duty as a first responder. The bill would also direct a court to order restitution upon conviction for any property damage caused by a rioter and require the bad actor to reimburse the property owner for the cost of restoring or replacing the property. Senate Bill 912 will provide added protection for our first responders and property owners alike. Thank you, and I'm happy to answer any questions.
Thank you, Senator Buckingham. Senators, any questions for the author at this point? Very good. We'll open up public testimony on Senate Bill 912, and the chair calls Ed Heimlich. Mr. Heimlich, come on down. Take your time. We'll wait for you. Mr. Heimlich's making his way down, and we'll look forward to hearing from him. And if anyone else wishes to testify on, for, or against Senate Bill 912, please register with the folks outside. I want to hear your testimony. Simon, welcome. Have a seat. Get situated there, and thank you for coming down. We'll wait for you. And when you get set up, introduce yourself and give us your testimony on Senate Bill 912.
I'm Ed Heimlich, testifying for Informed Citizens as their executive director. Please see inform.org and honorquest.org. I'm testifying on SB 912. The Honorable will read the Constitution. They have taken an oath to preserve, protect, and defend. And I'm sure that Senator Buckingham has read our Texas Constitution. Section 27 of our Bill of Rights decrees that the citizens shall have the right, in a peaceable manner, to assemble together for their common good and apply to those invested with the powers of government for redress of grievances or other purposes by petition, address, or remonstrance. The definition of the word remonstrance is forceful protest. We assemble in a peaceable manner through you. That is what a legislative session is. If our petition to our legislators fails, the people of Texas have a right to petition to court or turn to remonstrance. Informed citizens are not opposed to SB 912. However, as the doctor knows, addressing the symptoms will not address or eliminate the cause. The arrest and devaluing by Putin for his protests and the arrest of the Hong Kong protesters by China will not address or eliminate the causes. The arrests are more of an embarrassment to the government of Russia and China than were the protests. The arrests proved the protests were justified. The arrests may please the heads of government, but they bring those governments into disrepute. They cover up a tumor while the cancer is allowed to grow. Informed citizens petitioned our legislators to address the cause for the remonstrance so that SB 912 will not have to be enforced. Finally, I would say it's redundant. What it's saying, making illegal is already illegal in our penal code. Thank you.
Thank you, Mr. Heimlich. Senators, any questions for the witness? Thank you for being here. Anyone else present wishing to testify on, for, or against Senate Bill 912? Seeing none, public testimony is closed and bills left pending at this time. The chair now lays out Senate Bill 704. Senate Bill 704, and recognizes its author, Senator Buckingham, to explain the measure. Senator?
Thank you, Mr. Chairman. There is also a committee substitute, depending on how you want to do that.
One more time, I'm sorry.
I'm sorry, there's a committee substitute. I don't know if you want me to start regular.
Senator Birdwell sends up the committee substitute. Chair recognizes Senator Buckingham to explain the substitute. Thank you, Senator.
Thank you, Mr. Chairman and members. The purpose of this bill is to enact the statutory recommendations of the Sunset Advisory Commission for the Texas Racing Commission. As you know, the Texas Sunset Advisory Commission is tasked with identifying and eliminating inefficiencies in more than 130 state agencies. The Commission questions the need for each agency, looks for potential duplicative public services or programs, and considers new and innovative ways to improve each agency's operation. As a reminder, members, sunset bills are not the place to add additional policy issues, and I do not plan on taking any amendments on the floor. In 1986, faced with the budget shortfall, the legislature passed the Texas Racing Act, which authorized parimutuel wagering on horse and greyhound races and created the Texas Racing Commission to regulate the industry. However, the Texas racing industry has never been the economic driver originally envisioned due to a multitude of factors. As a result, the Sunset Commission determined that the Texas Racing Commission can no longer efficiently carry out its mission of ensuring the safety, integrity, and fairness of Texas parimutuel racing and wagering. After its review, the Sunset Commission voted to abolish the Racing Commission and its board and transfer the agency's functions to the comptroller. There is a committee substitute. The committee substitute transfers the regulation of the Texas to the Texas Department of Licensing and Regulation and reconstitutes the Racing Commission as an advisory board with the authority to advise the agency on racing. Members, this change was made as a result of lengthy discussions with stakeholders, and ultimately everyone involved felt TDLR would be the best home going forward. The Sunset Commission agreed to a 9-member advisory board at TDLR to advise the agency on racing. The board is made up of representatives from all across the industry and includes 2 public members. The advisory board would undergo sunset review at the same time as TDLR in 2033. Other major provisions of the bill include conforming the Racing Commission's licensing process with best practices and transferring administration of the horse industry escrow account to TDLR. Lastly, the bill applies standard sunset good government provisions on person-first respectful language. On the floor, you will be seeing an amendment to move the board from 9 members to 11 members. We figured out we had left out a couple stakeholders in that board, but it couldn't be done in time for the committee, so you'll see that on the floor. And thank you. We also have Sunset here as a resource.
Thank you, Senator Buckingham. Senator Birdwell.
Thank you, Mr. Chairman. I would remind Senator Buckingham that we have beer to go because I took an amendment on the TABC sunset bill, but that was a work that we agreed upon. So
it was a
well
valiant
done,
effort, Senator Birdwell.
Quick question. In reading the bill, I think the direction that Sunset's taking the Racing Commission is the right way to go. But it's a question of tactic, I guess. By December 1st of 2021, by September 1st of 2021, the Racing Commission dissolves and goes into TDLR. But by December of 21, it says the presiding officer of the Racing Commission should appoint this 9-member advisory panel. Should that be changed to they must make, because once it's dissolved, you no longer have a presiding officer. So you have a 3-month underlap. So should that presiding officer be required to make those nominations before September 1st of 2021, before it's dissolved and they're no longer a presiding officer of a non-existent entity?
I hear you on that. I don't know if we can check all the dates, and we definitely want to be sure that's lined up when we have a functional.
Because otherwise you've got somebody that's a presiding officer over nothing because it's dissolved, making nominations.
Yeah.
And in your layout, you'd mentioned, I think it was the committee subportion, that is this advisory panel a one-time nomination and they serve at the pleasure of whom? If the presiding officer is now dissolved, do they serve a 12-year term till 2023?
So it's my understanding that pretty much all of the sub-boards underneath TDLR operate in the same way, where the TDLR board appoints their board. So they will no longer be Governor Abbott appointees. They'll be appointed by the TDLR board.
Does the bill specify that in a rotating?
Yes, sir.
Okay, so what we really need to clear up then is the current presiding officer of the Racing Commission needs to make those nominations before September 1st of 2021, because he or she turns into a pumpkin on September 1st of 21.
And I think Sunset is here. They may be able to answer, but we'll double check that and be sure that it's as it should be.
Thank you, Madam Chair. I appreciate it. Thank you, Chairman.
Thanks, Senator Birdwell. Senator, any other questions for the author? Very well. Senator Birdwell, would you like us to bring up that resource witness to follow up on the discussion y'all were just having from Sunset?
Sure. If they know the question, if they can illuminate our understanding, that'd be greatly appreciated.
And if, Mr. Chairman, if we may, were you going to call them?
No, please go ahead. What would you prefer?
I was just going to say, if you want to call them while they're walking down, I would love to make a comment about my last bill if we have some time.
Oh, that sounds, we left it pending. I think that sounds great. Please go ahead.
Okay. Thank you, Mr. Chairman. I just want to say just after the witness who testified, the whole idea is that your freedom of speech allows you to protest and speak and do all of those things. But if you look at some of the videos to what happened, and I think we have Colonel McGraw over here, to some of our DPS officers, it is not okay for people to come after and intentionally harm our first responders. And there are plenty of examples of that. There are also plenty of examples where people's personal property, their businesses, their livelihood were burned and destroyed and looted, and there's no excuse for any of that, and that is not freedom of speech. Thank you.
Senator, that's right. Protest, even passionate protest, is uniquely American. We're for it, especially folks who disagree with us. But hurting people, destroying property, damaging property, physical harm, no way. That's not free speech. You're right. Amen. Thank you. Good morning.
Good morning.
If you're comfortable, would you remove your mask so we can hear you better when you testify? Thank you so much. And introduce yourself and tell us who you represent, please.
Good morning. I'm Lauren Ames. I'm the project manager for the Sunset Review of the Texas Racing Commission and a policy analyst at Sunset.
Thank you so much. Senator Birdwell.
I don't know if you heard my previous question of Senator Buckingham. The way I read the bill is the Racing Commission dissolves and becomes a subset of the TDLR agency. In dissolving, it still gives the power of the presiding officer who currently presides over the Racing Commission to make nominations through December 1st, even though they're the presiding officer of nothing beginning September 1st. So does the bill need a conforming amendment or some other drafting error type of an amendment that says the Racing Commissioner the current presiding officer has to make those nominations before the Racing Commission is dissolved.
The intention of the bill and the way that I read it was the presiding officer of the Texas Commission of Licensing and Regulation would appoint the advisory board, and the existing board at the Texas Racing Commission would continue to advise until the new board is appointed.
Okay, so the presiding officer of the TDLR makes that, not the presiding officer of the Racing Commission, who has historical context of those industries. But there's nothing that precludes the presiding officer of TDLR to consult with the Racing Commission presiding officer.
Correct. Under the bill, the Texas Racing Commission would be abolished on the effective date of the bill, but the board would continue until the new board is appointed by TCLR.
Okay. All right. Thank you, ma'am. Thank you, Mr. Chairman.
Thank you, Senator Bardwell. Senators, any other questions for our resource witness? Thank you for being here. Thank you. Okay. The chair now calls Tommy Azzopardi for Senate Bill 704. Welcome. You get situated there, then introduce yourself and give us your testimony.
Good morning, Chairman Hughes and members of the Senate State Affairs Committee. My name is Tommy Azzopardi. I'm here today representing myself and the groups that hold the racetrack licenses in Corpus Christi, McAllen, Laredo, and Fredericksburg. And I am here today testifying in support of the committee substitute for Senate Bill 704. Horse racing's been a big part of my life, and the groups that I represent and our entire industry supports having strict regulation to ensure the highest integrity, because without honesty, transparency, and patron confidence, our sport cannot and will not exist. It is imperative that we have a stable regulatory structure, and the approach outlined in this bill, with the ability to have the representation through an advisory board, will ensure that racing can continue to make the gains that we've realized in the last couple of years. I want to thank Senator Buckingham, her staff, and the entire Sunset Commission for the work they've done in evaluating the existing Texas Racing Commission and making recommendations to achieve effective, efficient regulation. We are confident that the Texas Department of Licensing and Regulation can bring the same quality approach to the racing industry that they have for the other industries that they currently regulate. Thank you for allowing me to testify today, and if you have any questions, I'm happy to answer them at this point.
Well, thank you very much. Senators, any questions for the witness? Thank you for being here. Thanks for your testimony.
Thank you, Chairman, members.
Anyone else wishing to testify on? We do have more, okay. So we have a number of folks who've presented themselves as resource witnesses. I'm going to call a few folks, and if you wish to offer testimony, you certainly may. That's going to be Robert Worstler, Director of Racing at the Texas Quarter Horse Association. Show Mr. Worstler is on the bill here as a resource. And so also Valerie Clark, Texas Quarter Horse Association, and Mary Ruyl, or Ryle, R-U-Y-L-E, Texas Thoroughbred Association. We had shown each of these folks as being on the bill here as a resource. So if any of those folks do want to offer testimony, please come on down. And anyone else wishing to testify on, for, or against Senate Bill 704. We'll give these three a chance to make sure we have their information correct. Come on down, have a seat.
Thank you.
And introduce yourself.
Yes, sir. Morning, Mr. Chairman, members. My name is Rob Worstler. I'm the Director of Racing for the Texas Quarter Horse Association, and I am just here in case you had any questions specific to the quarter horse industry.
Very good. And thank you for making that clear. That's what we thought. We just didn't want to miss anybody. Senators, any questions for Mr. Worstler?
Thank you.
Thank you for being here. So those are all the witness registrations we have. So at this time, public testimony will close on Senate Bill 704. Leave the bill pending at this time. Thanks, Senator Buckingham. You good? The chair now lays out Senate Bill 282, Senate Bill 282, and recognizes its author, our esteemed colleague, Senator Alvarado, to explain the measure. Good morning, Senator.
Good morning, Chairman Hughes. I have to do this to make sure I can see you. Good morning, Senator Hughes and members. It's nice to be here with y'all and appreciate the opportunity to lay out House Bill 282. This bill passed unanimously out of the Senate last time and got stuck in the House last session. But Texas law contains no prohibition on the use of appropriated funds to pay for sexual harassment claims by elected and appointed officials. Sexual harassment affects 2 out of every 5 women and 1 out of every 5 men in Texas. Y'all may recall in 2014, $84,000 in federal taxpayer dollars went to pay for a settlement for a sexual harassment allegation by a United States congressman from Texas. As a response, the United States Congress later placed a strong restriction on the use of federal taxpayer dollars to pay for federal sexual harassment claims. Prohibiting the use of state funds for sexual harassment settlements send a strong message to our elected and appointed officials that this type of misconduct will not be tolerated. Mr. Chairman, you and I have had a conversation about this bill, and I know you have some strong thoughts on that as well, that we don't need to be using taxpayer money to pay for misconduct by elected or appointed officials. Thank you. We have one witness, I believe.
Well, thank you, Senator Alvarado. Members, any questions for the author? Very well, thank you. We'll open testimony and call Catherine Strandberg. Catherine Strandberg for Senate Bill 282. We'll get that spot ready for you. Then, Ms. Strandberg, have a seat and get situated there. Then introduce yourself and give us your testimony.
Thank you, Chair, committee members, for having me. My name is Catherine Strandberg. I'm a senior policy advisor with the Texas Association Against Sexual Assault, or TASA, here to offer testimony in support of 282, which prohibits public funds from being used to settle sexual harassment claims against elected officials. We are the unifying voice to eliminate sexual violence in Texas. As the statewide coalition of rape crisis centers, our work encompasses training, technical assistance, and policy work to address sexual violence in Texas. Our membership includes rape crisis centers, survivors, sexual assault nurse examiners, law enforcement, and other allied professionals. Last session, the Texas Senate created its own policy around sexual harassment and affirmed that workers, including those who are in the chamber here today, deserve to be treated with dignity and respect at work. We thank you for your strong stance on this issue. So workplace sexual harassment is very common. A 2018 research survey found that 59% of women and 27% of men have received unwanted sexual advances or harassment both in and outside of the workplace. Of women surveyed, roughly half said they had experienced this harassment at work. So as common as sexual harassment in the workplace is, it also tends to go unreported. According to the EEOC, 75% of victims don't report their experiences to state or federal agencies. And victims of harassment often hope that it will simply go away, and they commonly experience embarrassment, fear, or feelings of hopelessness that prevent them from reporting. Researchers report that lost wages, lower productivity, and mental and physical health costs are all associated with workplace sexual harassment. So this bill prohibits state monies from being used to settle sexual harassment claims against elected officials. And I feel that it's narrow, but it is necessary addition to the government code that requires our public officials to take personal responsibility for their wrongdoing and protect us as Texas taxpayers from footing the bill on their behalf. Thank you for allowing me to offer testimony on this. I'm here if you have any questions.
Ms. Strandberg, thank you. Senators, any questions for the witness? Thank you for being here.
Thank you, Chairman.
Is there anyone else wishing to testify on, for, or against Senate Bill 282? Seeing none, public testimony is closed, and bill be left pending at this time. Thank you, Senator. The chair now lays out House Bill 1514. House Bill 1514, and recognizes its Senate sponsor, Senator Zaffarini. Senator.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 1514 is by Representative Brooks Landgraf. It relates to the administration of unclaimed property and was passed by the House unanimously. Generally, the bill would clean up the statutes governing the Texas Unclaimed Property Program to reduce administrative burden and eliminate ambiguities by first, easing reporting requirements of county clerks and aligning reporting timelines and requirements. Second, allowing the comptroller to adjust deadlines more easily during declared emergencies and disasters. Third, clarifying the comptroller's authority to sell unclaimed securities. And fourth, establishing the comptroller's authority to waive penalties or interest for late reported property for any good cause, among other provisions. There is a committee substitute that I'd like to send up at this time.
Senator Zaffarini sends up the committee substitute, and the chair recognizes Senator Zaffarini to explain the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute differs from the bill as filed in that it would eliminate the firearms from the list of personal property that is not subject to the Unclaimed Property Program. This provision was included in error and would result in the state with no means of managing unclaimed firearms. The comptroller staff intend to study this during the interim and identify a long-term solution. Thank you.
Thank you, Senator. Members, any questions for the sponsor of the bill? Hearing none, we'll open testimony. We have a resource witness here from the comptroller's office. Does anyone need to hear from the resource witness? Very well. No one else is registered to testify, so let's make sure anyone present wishing to testify on, for, or against House Bill 1514. House Bill 1514. Seeing none, public testimony is closed, and we'll leave the bill pending at this time.
Thank you, Mr. Chairman and members. Wish they were all that easy.
The chair now lays out Senate Bill 1612. Senate Bill 1612, and recognizes its author, Senator Hall, to explain the measure. Senator.
Thank you, Mr. Chairman and members. Senate Bill 1612, as filed, provides for important reform to election litigation, making communications between election vendors and governmental entities subject to open records, ensures election laws suits remain timely, and provides for writs of mandamus compelling election officials to comply with election code. And Mr. Chairman, I do have a substitute.
Senator Hall sends up a committee substitute, and the chair recognizes Senator Hall to explain the substitute.
Okay. Committee substitute SB 1612 will make our election process both simpler and more secure. The substitute is inserting important language that will remove the gap between early voting and election day, creating a single election period. Having a single election period is nothing new or rare, as over a third of the states currently have early voting and to end the day before Election Day. The single election period will allow for a consistent and uninterrupted time frame for voters to vote in person, as well as opening door for more greater checks on the integrity of our election process. The election period would be bookended with a complete printing of zero tapes immediately before opening of the polls at the start, and the printing of tally tapes immediately upon the conclusion of voting on Election Day, the last day of the voting period. Both the zero and tally tapes would be signed by the presiding election judge and deputy judge. The zero tapes will demonstrate that no machine has had any votes entered prior to voting, while the tally tapes will provide a record of how many votes were cast for each candidate or ballot measure on the machine. If a machine must be removed due to a malfunction, it must be kept in a secure, isolated location until the end of election. Making these changes will allow for greater opportunity for voters to vote while simultaneously restoring confidence in the accuracy and outcomes of elections. Mr. Chairman, I would just add that what this does is that one of the problems we've had with getting the tally tapes after early voting is that we can't reveal what the results of the votes were. So by doing this, we've not only removed the opportunity for untoward things to happen in that 4-day period between the end of early voting and election day, so that the votes remain more secure and that we can have a more closely monitored results by assuring that before the machines are moved, we have a count of what actually took place at each of the polling places with the tally tapes being printed at the end of the election period. And this is common practice. There are a third of the states, about 20 of them, that currently have this practice of just an election period. And so with that, I'd be happy to take any questions.
Thank you, Senator Hall. So, well, you explained it well. So then rather than having a period of early voting, which ends, and then election day, we just have a continuous series of days with no gap in between a period for voting. Is that right?
That's correct. And I'm sure we'll hear from some of the folks that are used to administering elections of this as kind of like a change that would mean that we do things slightly differently. But I think it would be a answer the question that I've heard most often from people is, when does early voting end? Or when is early voting? It now makes it a single period so that in person is no question about it. It's all the same. There's nothing different between early voting and election day. Simplifies it for the people and just makes for a little bit different process, but I think far less work also for them.
Thank you, Senator. Members, any questions for our colleague on the committee substitute? Senator Safrarini.
Are we changing the relating clause in the bill and in the committee substitute, broadening it in the committee substitute?
I believe that's right. And Senator Safrarini, you'll recall when we were debating some of the election reform bills, Senator Hall had an amendment along these lines that came up, and many members were open to the idea, but there was a concern that it had not been discussed and vetted in committee. So we have a resource witness here from Secretary of State's Office, Election Division, just to walk us through what would happen if we were to take this approach of getting rid of the gap between. So this was a good vehicle to get the topic in front of the committee for a discussion.
It's just that the relating clause in the bill as filed is so narrow, relating to certain suits involving elections and the confidentiality of certain communications with voting systems vendors. And then the new relating clause in the committee substitute is relating to elections. And it sounds like a Christmas tree.
Well, I think the author's intent is to focus only on this issue of ending the gap between. I'll let him speak for himself, but Senator Hall, that's my impression. Yes, you wanted this to be a vehicle to talk about ending that gap.
This was meant really to bring the topic, to get the subject before the committee and have some public testimony on it, rather than bring this up on the floor as an amendment that no one had had an opportunity to discuss it or a committee to be able to review it or have any testimony on it.
It just seems to me that new caption is so broad that this would be subject to countless amendments on the floor or in the House.
No, I have no intention of making any other amendments to this in any way at all. This is strictly to improve our election system by joining the other states that simplify theirs with a single voting period.
I think I like the idea of a floor amendment better. Thank you. Thank you, Mr. Chairman. Thank you, Senator Hall.
Oh, thank you, Senator. Senator Powell.
Senator Hall, which other states are we joining?
Glad you asked that. Alaska, California, Colorado, Hawaii, Iowa, Illinois, Indiana, Kansas, Michigan, Minnesota, Montana, Nebraska, North Dakota, New Jersey, Ohio, Oregon, Rhode Island, South Dakota, Vermont, Washington, and Wyoming.
Thank you.
An interesting mix of states.
It is.
It is. Thank you, Senators. The chair calls Christina Adkins from the Secretary of State's office. Ms. Adkins, welcome. You've done this before. Introduce yourself. Tell us who you represent.
Yes, sir. My name is Christina Adkins with the Secretary of State's office, here to testify on the bill.
Thank you, Ms. Atkins. And so I'm going to let Senator Hall ask some questions, but and then I may follow up. But you're in a position to see what this would look like in practice, and so we'd just love to kind of walk through it with you. Senator Hall.
I would just like to hear what you would have to say about the implementation of this here in Texas.
Sure. And just to make sure I'm clear on what we're talking about, and I think that you phrased this really well. You said this would be a new way of doing elections, and that the early voting period and the election day would kind of be fused together to one long period. Is that correct, sir?
That is correct.
And as I said, I think you're right. That would be a different way of doing elections. I think that right now there are provisions in state law that prescribe that, early voting is different from election day. There's some provisions that indicate that equipment can't be reused from early voting to the election day period. And so if that intention is still in place, to maintain some separation between those two periods, there would be some other provisions that we'd probably need to look at. And then beyond that, another consideration is that the results reporting would look different. If you were using the same equipment from election day or from early voting to election day, then your results would be reported with everything in one bucket. You wouldn't be able to distinguish between votes cast during early voting and votes cast during election day. And again, these are things that are doable. It's just a new way of conceptualizing how we run the election process.
Yeah, and in that separation of reporting early voting and then election day really serves no real purpose in the ultimate election of the individual, other than getting people an answer real quick that they want on what's been going on beforehand. There's no separate application of that early voting in the official process.
That's correct, and that when it all comes down to it, it's the totals for your election that are what matter, not so much when the votes were cast. I think, for record-keeping purposes, people like to know the difference, to be able to reconcile their records, post their rosters of who voted, make sure that the right people are on the list of being eligible to vote on election day. And so I think there's some, administrative reasons for that separation. And I think, anecdotally, I've heard that candidates like that information too. They like to know who votes early versus on election day.
They like that, but it seems to work out in about a third of the states there. And the other things that you talked about that we have in place of the laws, because everybody understands our election laws are a patchwork.
Yes, sir.
That have been cobbled over many years and multiple changes in technology that address the question of the day and sometimes ignoring what was around it before. This would kind of take a look at smoothing that out, bringing it all together. The issue about moving equipment and things like that is something that was created to fit the circumstances of it being separated. But I don't think that, do you see any problem in us being able to do this as a...
One other thing to consider when you're looking at changing that process from early voting to election day and kind of fusing it is to think about election security as well. There are security concerns with leaving equipment unattended and not protected, in the different locations. And, currently our early voting equipment has additional security requirements that don't exist for election day because of chain of custody concerns. The early voting ballot boxes have double locks. There are two locks. They have tamper evidence seals in addition to that. And then, of course, the counties track chain of custody. And there's a little bit of a difference in procedure because of the nature of early voting where equipment can be left for a specific period of time, a 1 to 2 week period, whereas with election day it never leaves the chain of custody of the election judge. So there's some differences in procedure. I think that there are some definite security issues that we would need to take a look at to address to leaving equipment for such a long period of time. So those are all things that we would want to look at in the implementation.
Well, to my way of looking at it, we actually increase the security because we don't have that 4-day period in there in which there is no activity and nobody's really sure what's happening with the machines or the memory cards. I know we have procedures in place, but it has a gap in there, whereas if it's all being used right straight through up to election day, it would make it far more secure with a one process instead of breaking it up.
And I hear what you're saying there, sir. And I agree. It's just a different way of conceptualizing how we would run elections. One other thing that you actually just reminded me of is that we probably would have to make sure that we're coming up with the right kind of procedures to deal with ballot box capacity issues too, as people, the ballot box can get full from the early voting period. And so, there's a number of logistics that we'd have to work out. But
it's procedures that need to be a little bit different.
Yes, sir.
Some cases more different than others.
That's correct.
But all workable.
Yes, sir. Again, whatever the policy is that the legislature tells us, we're going to find a way to do it. So.
Okay. All right. Thank you.
Thank you, Senator Hall. Senator Saffarini.
Thank you, Mr. Chairman. Ma'am, have you had an opportunity to read the committee substitute?
No, ma'am, I have not.
You have not. So you wouldn't be able to answer my question regarding whether the new content in the committee substitute, or at least perhaps you could answer in terms of what you heard about the addition in the new committee substitute, would it, in your opinion, be germane as a floor amendment to the bill as filed with that existing caption?
And ma'am, I'm sorry, since I haven't had the chance to review the full content, just from what I've heard, I don't know that I would be in a position to answer that question.
All right, with the new caption being 3 words, relating to elections, what kinds of amendments could be offered regarding the election code with a caption like this?
With a broad caption like that, I would think that that opens the door to a lot of different things related to procedure within the election code, specific to this issue, or maybe even a little bit broader than that.
Can you think of anything that would not be germane with a 3-word caption like that?
No, ma'am, I'm sorry. I don't think I have the experience to really answer that question, but I do agree that it is written broadly.
Okay. After the hearing, would you please read the committee substitute and then answer the question for me once you've read it?
Absolutely. Yes,
Thank you, ma'am. Thank you, Mr. Chairman.
Thank you, Senator Saffarini. Ms. Atkins, thanks for your testimony. I've got a few more questions, too. And to follow up on Senator Saffarini's inquiry, my understanding is that the code sections that are touched by a bill are what determine the bill's breadth. And the caption is a shorthand way to determine what's there, but my impression is that the parliamentarians, is it parliamentarians or parliamentaria? Anyway, the officers who look at the rules in the Senate and the House look at the bill and look at what code sections are affected to determine what amendments are germane. Is that your understanding?
That's my understanding, but again, my expertise is more in the election part, not as much on the legislative part.
Oh, thanks. And I want to get to the election part with you too. Thank you for your help on this. And you and Senator Hall walked through what it might look like. You mentioned there were administrative reasons for keeping them separate. Help us understand what those might be.
Sure.
That is keeping early voting separate from Election Day.
Sure. Because the process and procedure for early voting can have some variations with respect to how you cancel a mail ballot application or even just voting by mail in general, that there's other concepts in early voting beyond just early voting in person. When you have that distinction between the early voting period and the election day period, it gives our election workers the ability to reconcile their records, to review any of the voting records that have come in, to look at their roster, their list of voters, to look at people that may have initially applied to vote by mail but opted to cancel their mail ballot, either with the early voting clerk directly or by surrendering a mail ballot, and take the time to reconcile that with their list of registered voters for an election so that they have the ability to make sure that the list that's being presented on election day is the correct list and that all of those different situations have been taken into consideration when they're showing who's eligible to vote on election day and who's not.
And so that's helpful. And so it sounds like processes like that are there because we have this system with election day and with early voting. And I don't know all the history. I guess early voting, no excuse, early voting has been developing since the 80s and 90s, I guess. And so we had election day, then we added the early voting period. If we did step back and conceptualize election day as being 2 weeks long, or this election period, would it be possible to deal with those matters you just raised if we approach this and set up the system in a way that we just had a voting period that lasted for 2 weeks, 3 weeks, whatever it was? those administrative concerns, are any of those insurmountable from your thinking?
No, and as I said before, it's just a different way to conceptualize elections. The only other thing that I've thought about that I do want to make sure I relay to you all just to take into consideration is that, as a reminder that your early voting locations, the places where you vote during early voting, are not always going to be the same as your election day polling places. Sometimes they're the same with just maybe some expansion, different new equipment, more equipment, but sometimes they're different locations entirely. And so there would need to be some consideration in how we select our polling places, what the intention of their use is, and, the abilities to add additional locations for Election Day, since we do know a lot of people traditionally do vote on Election Day. And so there's a few other little things like that we need to give some thought to, but that's another example of something that would be distinctly different.
No, that's helpful. Let me ask you about that, and also the voting machines. My impression is that under the current system, the machines that we use during early voting are different than the machines. We don't use those same machines for Election Day. Is that right?
That's correct. Both in state law in Chapter 129 of the Election Code and in our Administrative Code rules, I believe it's 81.52 of the Texas Administrative Code, it prohibits any entity from reusing certain types of equipment from early voting to Election Day, largely for record keeping, for security reasons, and to ensure a distinction between early voting and Election Day, because that is the standard that we have in place now.
And you're certainly right about the polling places. I would think if we were to do this, we'd have to have the polling places consistent through the whole period. Mm-hmm. It sounds like if we were able to do this, we would have the benefit of more election machines because we wouldn't have to use some for early voting and some for Election Day. We could use all the machines during the whole period if we set it up that way. Right, if it was just one voting period without the distinction between early voting and Election Day. Does that make sense?
That makes sense. I understand what you're saying. If it were to be one long voting period and there's no distinction, then yes, it would open up the ability to utilize that equipment for both early voting and Election Day. Now, from a logistics standpoint, that's something I would probably need to consult with some of our county election officials on as to what that means, if they would need to obtain additional equipment to be able to meet those standards. I'd have to probably check on that. Just on that side, I want to kind of reserve that there in case I do have the ability to do a little bit more research on it. But yes, I think that if you were doing one extended period, it would open the door and that equipment could be used both times or for the extended period.
No, thank you. I'm getting in that way of thinking too. Thank you. That's helpful. And this helps just to conceptualize it. Senator Hall, did you have something else I couldn't see through the plexiglass we have to look through? Go ahead.
Yeah, which one am I looking at there? Yes.
Go ahead, Senator Hall.
Yeah, and all of what I'm hearing is it's just going to be different. It's not a major barrier there. Your point about the voting by mail, I think it'd be no different than all the way through early voting. If someone's asked for a vote by mail and then shows up at the poll to vote, that question is asked during early voting also.
Correct.
So it's just like making the last day of early voting is the end of the election. That's really all this amounts to, is because there's nothing special, and I don't mean this the way it sounds, about Election Day as opposed to election 2 weeks.
Correct.
It's all the same.
Essentially, what you're doing is still voting for your candidates, regardless of whether it's during early voting or Election Day.
And I think that as we look into it, and I would be very interested after you've had a chance to look at that, as Zaffarini, is to discuss it further with you. But what I see this is as I don't see how we could end up saying it's going to be more equipment required of them in this, because there's nothing being added to this as a result of it. It's just a different utilization of the equipment. Would you?
Yes, sir. No, I understand what you're saying, and I see what you mean, that it is just a different use of the equipment, using it in a continuous way.
Right.
I just am always hesitant to answer questions about what the resources would be like for our county folks unless I've had the chance to discuss this with them. But I do hear what you're saying, and I think logically that makes sense. The only other distinction is that, if looking at early voting and election day, you know, the number of polling places drastically increases for election day. If the intention is to have that election day number of polling locations available throughout the entire early voting period, we would also want to think about the demands that might place on our local entities for election workers, because that is a lot more workers that would need to be available for a longer period of time. So just something else to consider and think about.
Well, I think when you look at that, you'll see the way it's written, it's intended that for election day, they can add all the machines they want to.
And additional locations?
Additional locations, whatever, they can add that to it. It's just like overlaying election day with the early voting to meet whatever their particular needs are in there. So that's why I would say I don't see any more equipment. But I look forward to talking with you after you've had a chance to digest
We
this.
will review this in detail, sir.
Okay, thank you.
Thank you, Senator Hall. Senator Zaffarini.
Yes, and after you go through and look at the committee substitute, if you would specifically focus on whether we're talking about the alternative of having the early voting sites and then add additional sites for election day, or having all of the typical sites on election day available throughout the early voting period. It's two totally different concepts. And the way that it's written, I believe it would stand for the first, not for the second. But the second would certainly work a lot better. But if we do that, what would be the impact, the cost impact on all the entities involved?
If we were taking the number of election day locations that we have and extending that through the early voting period, there would be additional costs in some places for the use of those locations, but primarily it would be worker costs, increasing the number of workers that you're having to pay for that period of time.
And equipment?
And possibly equipment. It just, like I said, it depends on kind of how that process works out. But based on what Senator Hall's saying, if it's not changing anything in the numbers and that equipment is still the same, then it's very likely we're talking about the same amount of equipment.
And my other question is, the way that the bill is written, on election day, would voters have to go to their designated poll, their neighborhood, or could they vote at any place?
And that's something that I would have to look at the language here more specifically. But yes, ma'am, that's also something that we would want to consider if we're making a fundamental change in the structure of our elections, is how that affects precinct-based versus what we call countywide
I think that could be very confusing, unless we allowed everybody to vote everywhere, which of course I would love. Thank you. Thank you, ma'am. Thank you, Mr.
Thank you, Senator. Senators, any other questions for Ms. Atkins? Thanks for looking at this for us and helping us conceptualize it. Obviously, as Senator Hall noted, many states do this. It'd be a big change for us, but we ought to be open to whatever we can do to make the system better. So thank you for helping us through it.
Thank you.
Thank you. Look forward to getting it. Yes. Yeah.
Anyone else present wishing to testify on, for, or against the committee substitute to Senate Bill 1612? Seeing none, public testimony is closed. Bill be left pending at this time. The chair now lays out Senate Joint Resolution 61 and recognizes its author. Senator Campbell will explain the measure. Senator.
Thank you, Mr. Chairman, and good morning, members. SJR 61 shores up committee substitute Senate Bill 1675 that we passed out of this committee, allowing citizens of Texas to vote on a constitutional proposition that does the following. It gives legislature sole authority to amend, or suspend absentee ballots. It prohibits governor from amending or suspending absentee ballot laws, and prohibits local governments from amending or suspending absentee ballot laws. I knew I'd get that out. I do have a substitute.
Senator Campbell sends up the committee substitute, and the chair recognizes Senator Campbell to explain the substitute.
The substitute is simply a legislative council draft. It does not make any substantive changes to the bill. And with that, thank you.
Thank you, Senator. Any questions for Senator Campbell on the joint resolution? Chair opens public testimony, and the chair calls Robert L. Green. Bob Green, Bob, while you're making your way down, we're also going to be looking for Susanna Carranza. Susanna Carranza. And while we're waiting for them, Senators, do we want to call Ms. Atkins back? Do we need the resource witness on this bill or no? Okay, all right, thank you. So while Mr. Green and Ms. Carranza are making their way down, those are the only witnesses that we have registered wishing to testify on for or against Senate Joint Resolution 61. If there's anyone else, please do register outside. Mr. Green, welcome. Take your time. Get situated there. Good to see you. And when you get set up, introduce yourself. Tell us who you represent. Give us your testimony. Good morning.
Mr. Chairman, members of the committee, I decided to wear yellow today to honor you. Anyway, this is set up. I mean, we don't change rules in the middle of the game. We don't permit people to say, okay, in this half, we're going to allow everybody to hold. And that just messes up a whole system. So they need to remain constant, and we don't allow people to come in and in the middle of election decide, all right, we're going to change the rules. And this pretty much applies to everything. The qualifications for absentee voting, the qualifications to show identification, the qualifications to show that you are a resident of the county in which you are intending to vote. Anything with regard to this, you change the rules, you create a potential for problems. You create a potential for mischief. But that's pretty much all I have to say about this. I'll keep my testimony short. If there are any questions, I'll be happy to try and answer them. I wanted to say that I am the chairman of the Travis County Republican Party Election Integrity Committee, and I'm here today to testify in favor of this Senate Joint Resolution.
Mr. Green, thank you very much. Senators, any questions for the witness?
You bet.
Thank you for being here.
Thank you.
The chair calls Susanna Carranza. Susanna Carranza. Ms. Carranza, let us get this spot ready for you here, and then we'll hear from you. Welcome. All right. Get set up there, and when you're ready, introduce yourself and give us your testimony. Welcome.
Thank you. I'm Susanna Carranza, testifying on my own behalf, and I oppose the Resolution 61. Thanks for the opportunity to testify today. The proposed constitutional amendment hinders the ability of the governor and other authorities to respond promptly to an emergency that might affect the conduction of an election. Emergencies are by definition extraordinary circumstances, and the impact on the many functions of government, including the conduction of elections, really depends on each emergency. What good are emergency declarations if the legislator ties the hands of the officials and prevents them from adjusting procedures and guidelines to the specific emergency? We should make voting easy and safe for all eligible voters in all elections, including elections that happen during emergency. I urge you to oppose this resolution because it just makes it impossible to adjust to upcoming things that we don't know what's going to happen. Thank you.
Ms. Carranza, thank you for your testimony. Senators, any questions for Ms. Carranza? Thank you for being here. Anyone else wishing to testify on, for, or against Senate Joint Resolution 61? Seeing none, public testimony is closed, and the joint resolution will be left pending at this time. Thank you, Senator Campbell. for the benefit of those who are wishing to testify and also who are interested in the proceedings, we do have some bills remaining that were set, and we're working with the authors who are in other committees, laying out bills and hearing bills. So we're going to move forward here in a moment. And we do plan to hear some more bills before we have to stand in recess when the Senate comes in. So hold tight.
What's that?
The chair lays out Senate Bill 1111 and recognizes its author, our colleague, Senator Betancourt, to explain the measure. Good morning, Senator.
Good morning, Mr. Chairman. I hope this is the III bill at this point, but let me lay out Senate Bill 1111 for you. It's just simply ensuring about how voters are registered and simply to register where they reside. Voters are required to register where they reside in order to receive a ballot that contains certain races and issues where they live. Voters should be able to pick those districts. Currently, voters change their registration address in order to vote in different elections. In Harris County, we have approximately 4,880 that are now registering at private P.O. boxes. Unfortunately, this affects what the outcome of elections could be between where they should be voting and obviously where they're currently voting. So Senate Bill 1111 would make it crystal clear that voters may not establish residency for purposes of influencing the outcome of elections, but actually where they physically live. Additionally, SB 111 would emphasize that a person would not be prohibited from establishing a residence in a place that the person has not inhabited. And this is really quite simple because a P.O. box is not something somebody can live in. A 2-inch by 3-inch P.O. box should not be a residence address really for anyone in the state. And with that, I'll be happy to answer any questions.
Thank you, Senator Betancourt. Members, any questions for the author? Okay, we'll open testimony at this time, and Chair calls Chad Ennis. It's about a testimony on Senate Bill 1111. We're also going to be looking after Mr. Ennis for Ed Johnson. So we'll start with him, then we'll hear from some other folks. So, Chad Ennis. Looks like Mr. Johnson's here. We'll let him go first. Mr. Johnson, welcome. Have a seat. You know how to do this, but get situated and introduce yourself and give us your testimony. Good morning.
Yes, Ed Johnson, and I'm here representing myself for Senate Bill 1111. I spent almost 20 years in Harris County working in elections. And for a while, I was director of voter registration under a great tax collector assessor named Betancourt. During that time, went to all the Secretary of State conferences. They all said, every conference, how do you register voters? And one place they said you could not register to vote was in a post office P.O. box, because you can't live inside the little bitty box, because that's what the election code says. You have to have a place where you reside. So I really have had a hard time seeing what the difference between a post office box is and a commercial mailbox is. UPS stores, mailbox, etc. stores, they're the same little box. You can't live in them. And it's a growing problem. I know in Harris County, this last November election, we had 8,400 people, voters, voting in post office boxes. So it's growing. And it's a funny thing. The number decreases after the election's over with. I've seen hints of maybe vote harvesters getting a box and then canceling it and things. So I've seen other races actually get affected by these things. I've seen primary elections while I was there in Harris County that were affected by people voting in P.O. boxes. They were close races, and those votes would have made a difference. State rep races, congressional races, they're all. One of the latest crazes or trends that I saw is City of Houston sets up these limited purpose districts in the unincorporated part of the county where they annex all the businesses and collect a 1% sales tax. And when those businesses get annexed, you actually get to vote if you live inside the business in the City of Houston election. Unincorporated Harris County's moving to P.O. boxes and limited purpose annexation districts to vote in the City of Houston election. So, I mean, this is where voters are trying to select the districts that they want to vote in, and need to stop it, because you can't physically live inside of a P.O. box. Why we need this bill is when I was there actually in voter registration, had a group of them that we recognized were registering at one of these business mailboxes, and took it. This is not under the great Senator Betancourt, but took it to them. It's a different tax collector assessor. We took it to our county attorney, because the county was under a lawsuit for registering at businesses during the time. And the county attorney worked with the Secretary of State and determined that we had to register all these people there. So that's the answer when it comes in, is that you have to register these people when the registrars ask. The answer is they say register them at this business. So this law would clarify that no, these are P.O. boxes.
Thanks, Mr. Johnson. Senator, is there any questions for the witness? Thank you for being here.
Thank you.
The chair calls Chad Ennis, Esquire. Mr. Ennis, come on down. We'll get that space ready for you. And get situated there, then introduce yourself and give us your testimony. Welcome.
Good morning, Chad Ennis, Texas Public Policy Foundation, testifying in support of the bill. We think this is a really good bill. One thing, the statistics have shown us that in 2018, Texas had the second highest number of voters registered at non-residential addresses. We're doing a little better than California, who had over 7,000, but that's not a list you want to be near the top of. This bill would go a long way to addressing that problem. One thing we like about it also is it clarifies the way that you can demonstrate your address if it's challenged. It lays out perfectly the roadmap for the voter to show where the voter lives, and that will make it uniform across the state, which I think is important, that the residential address is the same in, or requirements are the same in Fort Worth as they are in Tyler. So that's a good thing that this bill requires. For those reasons, we're in support of the bill. We'll take any questions.
Mr. Ennis, thank you. Any questions for the witness? Thank you for being here. We'll open public testimony, and the chair calls Alan Vera. Mr. Vera, come on down. After Mr. Vera, we'll be looking for Susan Carranza, James Slattery, David Griggs. Mr. Vera, welcome back. You know how to do this. Introduce yourself and give us your testimony.
Good morning. Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of SB 1111. There are two layers of voter eligibility. We often forget the second. The first one is, am I a citizen, am I of age, etc. The second one is, are you eligible to vote in this election? And that second layer is all determined by residency, where you live. Are you in that school district, etc. In July 30, 2018, I filed a voter registration residency challenge with the Harris County Voter Registrar, challenging 4,027 voters who were all registered at commercial P.O. boxes. As I frequently do in Harris County, I got a lot of pushback from the county attorney, the county clerk, the voter registrar, who tried to deny my challenge. Then I got an autographed opinion from the Secretary of State then, Rolando B. Pablos, who said, Mr. Vera is correct. All the information on his challenge is right. Execute the challenge. So the letters were all sent out. Remember, 4,027 voters I challenged in P.O. boxes. That same year, there was a runoff for the mayoral race, and the incumbent mayor won his runoff by 4,000 votes. And a month later, half of those 4,027 people had moved their voter registration address out of the Houston city limits to places unknown. That's why SB 1111 clearly states a person may not establish residence for the purpose of influencing the outcome of certain elections. That's why this is being done. They're registering at P.O. boxes to influence elections. Ask you to please support SB 1111, report it favorably to the full Senate. Thank you.
Senators, any questions for Mr. Vera? Thank you for your testimony. The chair calls Susan Carranza. Susan Carranza. While we're giving her some time, did I see Mr. Slattery? Did I see James Slattery? Ms. Slattery, come on down. If you, chair calls James Slattery, and we're still going to be looking for David Griggs and Susan Carranza. Ms. Slattery, welcome. Get situated there and introduce yourself and give us your testimony.
James Slattery testifying against SB 1111. SB 1111 would require voters responding to a confirmation notice to supply evidence of the voter's residence address by providing a copy of one of the documents specified in Section 4 of the bill, such as a driver's license, license to carry a concealed handgun, utility bill, etc., unless they qualify under one of the narrow exceptions also listed there. This evidence requirement clearly violates the Federal National Voter Registration Act, which allows a voter to respond to a confirmation notice by simply stating in writing that they are registered at the correct address. It would therefore ensnare Texas in needless and expensive litigation from the moment it is enacted, which Texas will lose. Even if it is somehow implemented despite blatantly violating federal law, we know that in practice it will result in many Texans being wrongly removed from the rolls. Many tens or hundreds of thousands of confirmation notices are sent out each year. As it stands, many people fail to respond because they simply do not see the notice. Adding an additional requirement to photocopy proof of residence would only exacerbate the non-response rate by imposing a new and unnecessary burden on voters, disenfranchising more voters, and ultimately making the rolls less accurate by excluding eligible and properly registered voters. We therefore recommend the committee not report the bill out favorably to the full Senate. And I should have said I'm testifying here on behalf of Texas Civil Rights Project.
Got it. Thank you. Any questions for Mr. Slattery? So let me ask you. I know you were here for some of the testimony. P.O. boxes. So if we're talking about a P.O. box at the post office, the U.S. Post Office, an official P.O. box, what about that as a residence for voter registration? There's been some testimony about those. I want to ask first about those. Is that in your view, is that an acceptable, if I list my P.O. box in that city, is that enough of a residence to entitle me to vote there?
You know, I'd have to get back to you on that. We focused on the NVRA violation, which we... No,
I understand. And I was curious about that because it looks like there's pretty good agreement on a post office box, the official at the post office, but then these private mailboxes, right? Maybe at a UPS store or something else. Did you hear the testimony about how thousands of voters were registered to vote at a mailbox and not a place where you can't sleep or live? Did you hear the testimony about that?
Only part. I was coming down from the gallery.
Okay, so do you have a position on whether folks should be able to claim as their residence a literal post office box that's too small to live in?
We, other than everyone should be complying with the law at all times.
No, sounds like good policy. Thank you very much. Any good questions for Ms. Slattery? Thanks for being here. Chair calls Susan Carranza. There's Ms. Carranza. Welcome back. We'll get you set up there and get set up and introduce yourself. Give us your testimony.
Thank you. I'm Susanna Carranza, testifying on my own behalf, and I oppose Senate Bill 1111. Thanks again for the opportunity to speak. I oppose this bill because it imposes an extreme burden on a voter to confirm their residence address. While I agree that we should follow the law and try to prevent people from abusing the system, this bill is so restrictive that will disenfranchise large numbers of voters that are not doing anything wrong. This bill makes, for example, virtually impossible for any voter that has normally transient or insecure housing unable to vote because the documentation burden is extremely complex. For instance, under current election code, a person experiencing homelessness can use a location that's not an actual resident as their address. And it can be usually a place where they would spend most of their time or keep belongings or anything like that. So in your question of the UPS PO box, let's say if that's the corner that a homeless person lives, that person could use that. I'm not saying that's all the case, but that's actually a valid reason to claim a PO box. Not a PO box, but a UPS box as their location. This bill also exempts truck drivers, but it doesn't allow for any other professions that might also have transient living conditions. So this bill is excessively restrictive, provides a huge burden on the voter, and I urge you to oppose the bill. Thank you.
Thank you, Ms. Carranza. Any questions for the witness? Thank you for being here. Thanks for your testimony. The chair calls David Griggs. David Griggs. Mr. Griggs, welcome. Get situated there, then introduce yourself and give us your testimony.
Thank you, Mr. Chairman, Senator Hall, committee. My name is David Griggs. I'm from Dallas. I've been here before, and thank you for having us back to talk about some of these bills. I'm representing the Lone Star chapter of the Sierra Club today, as well as myself. And if you remember from previous testimony, I'm a 26-year veteran election judge. And so I don't have any prepared remarks. I just want to talk to you about some logistical things that I see that's a problem. There are several things in this bill that appear to be reasonable, but there's one particularly that I think is going to be a problem, and that is the in Section 3, where you've made some changes, requiring that when a voter receives confirmation notice asking for confirmation that they live at that address, then they have to respond with a sworn affirmation and evidence of the voter's residence address or an indication that they're exempt. Mr. Chairman, this is another instance where an extra burden is being placed on the voter for not a real strong reason. Now, there may be some reasons for post office boxes and other things in here, but this particular one I wanted to register my concern about and encourage you to take a closer look at this section. Thank you.
Thanks, Mr. Griggs. Any questions for the witness, senators? Thank you for being here. Thanks for your testimony. The chair calls Bill Sargent. Ms. Sargent, you've also done this before. Welcome back. Introduce yourself and give us your testimony.
Bill Sargent, former Chief Deputy Clerk for Elections in Galveston County. I'm in favor of this bill. And I have one question for you to consider as you consider this legislation. Does a post office box have a bathroom? Does it have shower facilities? Does it have a place where you can sleep? I think the answer to that question is no. If you can't live in a post box, then that's not your residence. That's all I have to say.
Thanks, Mr. Sargent. Any questions for the witness? Thanks for being here. Anyone else present wishing to testify on, for, or against Senate Bill 1111, Senate Bill 1111? Seeing none, public testimony is closed. The bill will be left pending at this time. The chair now lays out Senate Bill 1589, and recognizes its author, Senator Betancourt, to explain the measure. Senator?
Thank you, Mr. Chairman. I do have a committee substitute.
Senator Betancourt sends up the committee substitute. The chair recognizes Senator Betancourt to explain the substitute.
Basically, the substitute reduces the number of election marshals required under the bill from 1 per 250,000 to 1 per million. Substitute also clarifies Secretary of State as full enforcement authority over the Texas election code in regards to the bill. And during the November 2020 election, the lack of enforcement tools and also the lack of resolution of election issues became very apparent. The bill really basically has two halves. One, it sets up an election marshal side that it can be.
Senator Betancourt,
yes.
I apologize. I erred. Hold tight just for a moment. I've been reminded that only a member of the committee can send up a committee substitute. My mistake. So Senator Hall
that's right.
is sending up the committee substitute, and now you're recognized to explain the substitute. Go ahead. Thank you.
Thank you, but I appreciate the adoption clause on state affairs for the bill. Thank you. So, the committee substitute reduced the number of election marshals required from 1 to 250,000 to 1 per million. It also clarifies Secretary of State as full enforcement authority over the Texas election code. And really, when you look at the November 2020 election, there were issues that could have been resolved quickly and efficiently if there were marshals in the field to do it, as well as the fact that the bill also sets up a quick judicial loop that basically puts the local administrative districts into the position of pre-positioning judges and making sure they're prepared to hear election cases. Because we want problems to be resolved, and we want them to be resolved quickly, because that's the bedrock of democracy. And I think the bill sets up a good balance between having experienced people that in the field, and we'll hear from Director McGraw as a resource witness, or invited resource witness. And importantly, I think that everyone who's been through an election process realizes how important it is to be able to get to a judge if you have an election dispute within 3 hours in early voting or 1 hour on election day and resolve any problems. With that, I'd be happy to answer any questions, but I do want to point out that the election marshals will basically be dispatched by Secretary of State to review any violations that are reported to the Secretary of State, and then request the election marshals to address and investigate the situation. And then in support of the election marshals, and really at all the candidates and political parties that are on the ballot, or even issue-related ballots, the 11 judicial regional administrative judges will have appointed judges to be available immediately during the 45 days before the election through Election Day to hear complaints electronically. These judges will be trained on election law prior to their nomination. And additionally, as I mentioned earlier, the election code specifically gives the Secretary of State authority to enforce against abuses of voting rights. The authority to enforce against the violations of election code is not clear, and the committee substitute would for Senate Bill 1589 would clearly state Secretary of State's authority to enforce the election code. Be happy to answer any questions.
Senators, any questions for Senator Betancourt? Very good. We'll open up testimony, and Chair calls Alan Vera. Mr. Vera, welcome back. And after Mr. Vera, we'll be hearing from Chad Ennison from Colonel McCraw. And Senators, I'll also note that we do have Keith Ingram here as a resource from the Secretary of State's office. So if you'd like, thank you. If you'd like to hear from him, let me know. Mr. Vera, welcome back. Introduce yourself. Tell us who you represent. Give us your testimony.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of SB 1589. Texas can have the best election laws in the country, but if we don't enforce them, our laws are moot. Our Ballot Security Committee in Harris County appoints all the election judges and clerks for early voting and election day, all the poll watchers, and all of the Signature Verification Committee, Early Voting Ballot Board, and Central Count. So last November, we deployed 2,600 people into the field. That's a lot of sets of eyes and ears, and they do a good job reporting back to us on everything going on. On October 14th, retired school teacher and trained poll watcher Catherine Vanderpool was denied entry to the Signature Verification Committee. The presiding judge wrote on her certificate, "No poll watchers allowed in SVC," and signed it. County clerk would not overrule it. The county attorney would not overrule it. The district attorney would not overrule it. That is a criminal offense under TEC 33.061, and nobody would do anything about it. So the system failed Ms. Vanderpool and her sponsoring candidate. In an early voting location in early October, for the first week, an election judge nicknamed Scully pressed the cast ballot button 3 times when voters left the booth. That's a felony. The county clerk did nothing, the county attorney did nothing, the district attorney did nothing. The SOS at least sent an inspector who tried to do a good job of explaining things, but inspectors have no enforcement capability or authority. The system failed good election workers, both Republican and Democrat, who wanted to do the right thing. In early October 2020, a young Hispanic mother of a blind daughter called the Houston Sheriff's Department because as she came out of the food town at FM 529 Highway 6, people approached her to offer her gift cards if she would take handfuls of mail ballots home, sign the envelopes, and mail them in, and they'd even provide the stamp. The Harris County Sheriff says, "I'm sorry, we don't do voter fraud. You'll have to find someone who does." Again, our system failed a good citizen. These are just 3 of hundreds of cases reported by our 2,600 people in the field. There was nothing done because all the local authorities contacted declined to take action, and the state authorities don't have the bandwidth. They want to, they just don't have the resources. Here's a short but relevant analogy. You're the manager of a JP Morgan Chase branch bank. It's in the middle of the day, and someone with a blowtorch and a crowbar is trying to break into your ATM machine to steal all your money. You call law enforcement for help. You need someone right away to stop the crime before it's finished. You need someone to prevent your money from being stolen. But the person answering your call says, "I'm sorry, if you'd like, you can file an online complaint, and we'll refer it to somebody who'll review your case to see if it's credible, and we might respond." I don't think any of you disagree that would be a totally unsatisfactory approach to dealing with a problem. And there's our double standard here in Texas. If someone is stealing money, we move heaven and earth to respond immediately to fix the problem. But if someone is stealing votes, stealing ballots, please file an online complaint, and we'll get back to you if someone wants to investigate it. SB 1589 doesn't demand DPS come flying in with sirens blasting and lights flashing, doesn't call for SWAT teams. This bill simply says that when a credible report is made of an election violation that's also a criminal penalty or criminal offense, our best officers, the best in Texas, DPS, will go to the scene to investigate. It might take them an hour to get there. It might take them 2. And maybe you think 2 hours doesn't seem like real time, but compared to what we have today, 2 hours would be a blessing. These officers will have been trained in election law. They'll at least know what questions to ask, and when they ask their questions, their body cams will provide great evidence of exactly what's said by whom. This is an important opportunity for all of us to bridge our words to actions. Today, we tell voters that we think their vote is very important. But our laws tell voters that your votes aren't as important as money. If we really want to act, if we really believe that votes are at least as valuable as money, this bill forces us to act like it. If you want to show Texans that you hold their votes to be at least as valuable as money, please refer SB 1589 favorably to the full Senate. Thank you.
Mr. Mayor, thank you. Senator, is there any questions for the witness? Thank you for being here. The chair calls Chad Ennis. Mr. Ennis, welcome back. We'll have that spot ready for you in a second. Introduce yourself. Tell us who you represent. Give us your testimony.
Thank you, Chairman Hughes. This is Chad Ennis. I'm with the Texas Public Policy Foundation, and I'm testifying in favor of the bill. This is a good bill. One of the things that is really important about this bill is to have dedicated, trained election marshals that have been through, something more rigorous than we have now. So they're able to investigate these cases efficiently and quickly. And these are not easy cases to make. They're white-collar cases for the most part. They take time and energy in having a trained staff will be very beneficial in the investigation. And also the provisions on the speed through the courts, I think, are really important. Getting these cases in front of judges day of when they're happening to get things stopped before it gets big is very important. But we support the bill and would take any questions now from the committee.
Mr. Ennis, thanks. Any questions for the witness? Thank you for being here.
Thank you.
Colonel, the chair calls Director Steve McCraw, Texas Department of Public Safety. Colonel McCraw, welcome. Good to have you. Even though we know you, introduce yourself. Tell us who you represent.
Yep. Thank you, Mr. Chairman. Steve McCraw, Director of Texas Department of Public Safety. I'm here on the bill as a resource witness.
Director, thank you very much. So I know you've had a chance to, if only recently, look at the committee substitute. And,
yes, sir.
And you're familiar with the legislative process. From the DPS standpoint, do you have concerns about implementation of the bill, what the bill might look like? Do you have any thoughts how we might do it better? Just to tell us what you think.
Well, I know I talked to Senator Betancourt about using reserve officers as an option as well, which is certainly a force multiplier. I mean, the Department of Public Safety certainly doesn't have a comment or resource position on the bill. But however, whatever the state legislature wills, and you will many vital responsibilities, the Department of Public Safety will do the best job we can at it. I can just tell you that.
Well, Colonel, thank you. And we certainly all respect the fact that state agencies and those representing state agencies don't take official positions because the legislature implements the will of the people. And so we just want to make sure that we're looking for the landmines and that sort of thing. So, Senator Betancourt, do you have any questions for Colonel McCraw? Senator Hall, do you have any questions for Colonel McCraw? Colonel, thanks for being here. Thanks for serving us. Thank you very much. We'll open public testimony, and the chair calls Olga Rivera Lasher. And I know many of these witnesses may be upstairs, so I'm going to ask the following folks to be making your way into the Senate chamber: Olga Rivera Lasher, Scott O'Grady, Carla Burke, Kenneth Moore, Bill Sargent, Valerie DeBill. And Captain, come on over. If you're already here, we'll put you in the spot. Hold on just a second, Captain. The chair calls Scott O'Grady. Welcome, introduce yourself, and give us your testimony.
Thank you, Mr. Chairman and Senators. On behalf of Texans for Election Integrity and myself, Scott O'Grady, I'm here to support Senate Bill 1589. I live in Dallas, and during early voting for the November 2020 election, I was a poll watcher at 5 locations in Dallas County. At all 5 locations, I was blocked by election judges from being able to verify that voters were properly registered. At 4 locations, election judges ordered me to be removed from observing the sign-in terminals and placed me on the opposite side of the sign-in desks. The 5th location had me placed so far away I could not read the sign-in terminals to verify a voter was properly registered. Even though currently obstruction of a poll watcher is a misdemeanor, I experienced similar treatment by election judges and their staff at all 5 locations. In all 5 locations, I witnessed common means of committing voter fraud. One means was numerous mail-in ballots were surrendered at every location, yet procedure of physically canceling those ballots and issuing provisional ballots to vote in person was not followed. At one location, after the polls closed, the election judge tried to remove me from observing how they handled surrendered mail-in ballots and called the police on myself and fellow poll watcher. Police arrived and showed no understanding of the obstruction of a poll watcher as a misdemeanor. SB 1589 calls for state inspectors and trained election marshals to investigate any alleged voter fraud. Even though I submitted written reports on all that I observed as a poll watcher, I felt there was insignificant oversight by the state of Texas to investigate acts of voter fraud to ensure Texas elections are transparent and fair. SB 1589 would allow poll watchers' observations to be properly investigated versus leaving their reports in the hands of lawyers. I would encourage the passage of SB 1589.
Thank you for your testimony. Thank you for sharing your experience with us. This is an important part of the process, and so thank you for being here. Thank you very much. The chair calls Olga Rivera Lasher. Olga Rivera Lasher. Take your time, get situated there, and
thank you.
Introduce yourself and give us your testimony, please. Good morning.
Thank you. My name is Olga Rivera Lesher. I'm representing myself, and I am speaking in favor of this bill. I have worked the elections in Travis County since the early 90s when we retired from the Marine Corps. I say we because when your husband decides to dedicate his life to the military, you're automatically enlisted. As an election worker, I've done everything from poll watcher, early voting ballot board, presiding and alternate presiding judge, both at the precincts and at Central County. I've been the primary elections administrator for the Travis County Republican Party, so I know a little bit about what I'm talking about here today. There were very serious discrepancies, irregularities that occurred at this last election in Travis County. Obstruction of poll watchers. And let me tell you, if this bill had been in effect, an election marshal would have been assigned to this violation, resulting in our poll watchers having been allowed to do our job, as well as in those chain of custody cases with pertinent voter information where there was no Republican presence. To have had a poll watcher present would have been ideal. Instead, the poll watchers had to endure the humiliation of being rounded up by election officials and put in what the poll watchers termed the fishbowl, some 20 feet away from activities and where our vision and audio was more than often obstructed. The obstruction of our poll watchers this last fall, I believe, had nothing to do with COVID protocol. COVID was the excuse. Where in the past we have had to wait until the elections were over to take our concerns and complaints to the proper channels, with this bill in place, having had a marshal assigned to this legal violation, our poll watchers would have been able to do their job. In addition, the county officials failed to honor our party's list of election workers that had been duly appointed to serve. And while we may not, and you're going to hear more about this, while we may not be able to prove that the list of irregularities that occurred may have resulted in voting fraud, the atmosphere of it does create the environment where accusations of fraud gain credibility. Having election marshals not only makes sense, but it is also beneficial to all rightful Texas voters. Thank you for your time.
Thank you for your testimony. Thank you for being here. The chair calls Carla Burke. Ms. Burke, come on down. We'll get that space ready for you. After Ms. Burke, we're going to be looking for Valerie DeBill, Kenneth Moore, and Bill Sargent. Ms. Burke, welcome. Get situated there and introduce yourself and give us your testimony.
Hello, my name is Carla Burke, and I'm representing myself. I'm speaking for SB 1589. I have worked the elections in Travis County for over 10 years in many roles. There's a lot I could tell you. Today I'm going to speak about the poll watcher obstruction and improper judge appointments last fall as examples of problems that could be remedied by this bill. I was a poll watcher at Central County in November. Poll watchers were placed in a separate room with windows into 2 other rooms where the election activities were taking place. Activities included mail ballot scanning, loading and tabulating votes, remakes of damaged ballots, and delivery of the memory sticks for the polling locations. We were about 20 or more feet away from some of the activities, making it impossible to read reports and computer screens in order to confirm ballot counts and seals. We could not witness the chain of custody of memory sticks and ballots from that position. It was difficult to hear the conversations being transmitted over a smartphone speaker, and sometimes for hours the speaker was not working at all. On election night, when the early votes were tabulated, the large computer display intended for poll watchers was intentionally turned off. The monitor faced opposite us. Later examination of audit logs showed multiple errors, including invalid devices and uncertified media, had occurred during that time. Although the Attorney General had issued an opinion about poll watcher distance, the election officials refused to follow those. To get relief, the Travis County Republican Party and a candidate filed with the courts and a lawsuit. An agreement was not reached until the 12th and final day when the counting was basically over. The second problem we experienced was the appointment of judges for the polling places in central counting by the county clerk did not follow the TEC. The party correctly submitted its list of term appointments to the clerk on June 26th. The clerk did not file the appointments with the Commissioners Court in July as required. Even when the party brought this to their attention, they ignored the party's concerns and kept their own appointed judge at the central counting. While these irregularities don't prove elections fraud, I can say that they seriously and rightfully erode trust in the system, and therefore I ask you to provide mechanism for timely and effective resolution.
Thank you for your testimony. Any questions for the witness? Thank you for being here, Ms. Burke. The chair calls Valerie DeBill. Valerie DeBill. I beg your pardon? Oh, very good. Thanks. So we'll show Ms. Bill's position on the bill, but not wishing to give testimony. Thank you. Chair calls Kenneth Moore. Kenneth Moore. While we're looking for Mr. Moore, we'll also call Stephanie Baker to be making your way down, and then we're going to hear from David Griggs again, and also Ed Johnson. Welcome. Introduce yourself and give us your testimony.
Greetings, committee members. My name is Kenneth Moore.
Mr. Moore, get a little closer to the microphone so we can hear you well. It's okay.
My name is Kenneth Moore. I am the chairman of the Ballot Integrity Committee for Brazoria County. I'm here representing myself. I am for this bill. Committee members, even the best laws written mean nothing if they are not enforced. What good is a fire department that picks and chooses which fires they will put out? And what good is a fire department that waits 6 months to show up with hoses and axes when the house is already destroyed? This describes the spotty enforcement of the election laws have been subjected to for the last couple of years. This bill addresses this issue. Now, we in Brazoria County are fortunate that we've been spared a lot of drama that other counties have had. But we look at our neighbor to the north, Harris County, and we see the things going on there, and we see this whole thing coming our way. We are trying to prepare for it, and this bill will go a long way towards addressing that. And so I urge you to please pass this bill on to the whole Senate.
Ms. Moore, thank you for your testimony. Any questions for Mr. Moore? Thank you for being here. Chair calls Bill Sargent. There he is. I thought I saw you back, Mr. Sargent. Welcome back. Have a seat there and introduce yourself. Give us your testimony.
Bill Sargent, former Chief Deputy Clerk of Elections for Galveston County. I'm testifying on behalf of myself. Have you ever had to work a jigsaw puzzle and found out that you're missing a piece? Do you remember how frustrating that was? That's what's happened with election integrity legislation this session. Both SB 7 and HB 6 are missing a critical piece. The legislation before you today is that piece. All the good work that's already been done, hard as it has been and as heavy a lift as it has been, will not have much impact until we actually have boots on the ground to enforce it. When I testified before you on SB 7, I demonstrated an example of how the damage has already been done if you rely only on the judicial process. You must have real-time enforcement, or those who won't let poll watchers in the door and those who let them in the door but tell them to go over in the corner and sit quietly will continue to violate the law. Using the existing DPS officers is a brilliant idea. It will will not impose a major physical note on the or issues, because it only adds to the duties of existing DPS officers, and for short periods of time. Once they've been trained by the Secretary of State's office, they will bring to the table a knowledge not only of the Texas Election Code, but also the tools available to peace officers in our state. The Attorney General's office does not have the staff to do this job on a real-time basis, but DPS does. This is the piece of the puzzle that is missing. You must have real-time enforcement that this bill provides. Don't slow walk this measure, pass it out of your committee, and get it done. Finish what you started.
Sergeant, thanks for your testimony. Any questions for the witness? Thank you for being here.
God bless you and thank you.
Thank you. Chair calls David Griggs. See Mr. Griggs back down here. Mr. Griggs, welcome back. Get set up there and introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. Glad to be back. Thank you, Senator Hall and the rest of the committee for being here today. In a word, Mr. Chairman, let me just repeat, I'm David Griggs, representing the Lone Star chapter of the Sierra Club. I'm here to testify against SB 1589. In a word, Mr. Chairman, this bill is just simply not necessary. But aside from that, I want to point out a couple of issues, real concerns that I have. First, in Section 3, it says here, where two or more registered voters or an election marshal presents affidavits alleging criminal conduct, it requires that the county or district attorney shall investigate those allegations. Not may, not should, can, will. It says it shall. So it's dictating to that district attorney what they have to do to determine criminal activity. So my question is, what is criminal activity? Who decides that? And I'm concerned because I was here testifying against Senate Bill 7 a couple of weeks ago, where you criminalize in that bill certain actions by the election judge or workers regarding poll watchers. I'm concerned with the interplay, if Senate Bill 7 were to pass with that provision, and how that would define criminal conduct here. It just raises some concerns for me. Also in Section 8, this creates a whole new emergency review process for anticipated energy or emerging reviews here or emergency reviews. I'm just wondering, where are you expecting a flood of these types of issues to come up? I think we're potentially creating a process here that would beg participation, and I'm concerned about that. Where are you going to get all of the visiting judges to replace the judges in the counties where there is a problem? So in conclusion, as to the poll watcher who talked about this earlier, who said that they were blocked, I would never block someone from seeing anything in my polling place because I think they deserve to see it. But I think we fix this problem, Mr. Chairman, by training, by simply helping to educate the judges and the poll workers as to the best practices here. We don't need laws like this that criminalize the process and take a sledgehammer to what a screwdriver is needed to fix. So that's my testimony. Thank you, Mr. Chairman.
Mr. Reeves, thank you for your testimony. Thank you for being here. The chair calls Stephanie Baker. Baker, welcome. We'll have that ready for you in just a second. There you go. Have a seat. Introduce yourself. Give us your testimony.
My name is Stephanie Baker. I'm a resident of Dallas County, and I represent myself. I support this bill. During 2020, I was a paid election worker for early and election day voting. I've served as a poll watcher. I read, scanned, and compiled poll watcher incident reports. I'm a voter registrar and will be a judge in May. I was personally obstructed 4 times and my husband 3 times and escorted off properties. I'm aware of 151 instances of major election law violations in Dallas County based on the Dallas County Republican Party resolution in March 2021, which I can get to you. The worst case scenario, deputies arrived 16 times and were used by the judges to commit Class A misdemeanors by unlawfully escorting poll watchers from the premises when watchers were executing their rights under Texas law. Midway through early voting, the dispatcher for the Dallas County Sheriff's Department stopped sending deputies when poll watchers would call. Indeed, the one time I called, the deputy told me that they were only there to support the judges. The Dallas County Republican Party reported these incidents to the Republican Party of Texas, the Secretary of State Elections Division, and the Office of the Attorney General, who apparently only had time to send emails, which the Dallas County Elections Department chose to ignore until the very last day of early voting, when the judge of the largest early voting location walked off the job after being reprimanded. She said she was only doing what she was instructed. Without SB 1589, my belief is that the election law will continue to be ignored in Dallas County when the party that controls the election department, the DA's office, and the sheriff's department think that what's going on right now is favorable to their party. I personally witnessed a continuation of these same issues last week during election judge training. The same things are going on. Dallas is using a paraphrase of the law, not the law. So the judges go in there with their paraphrase, the poll watchers go in there with the law, and the judges win. Please support this bill. Thank you.
Ms. Baker, thank you for your testimony. I want to make sure we have our records clear. We showed your registration as being on the bill. It sounds like from your testimony that you are for the bill. Did I get that right?
It is. The only question that I have is how do we make sure that the marshals are not just loyal to one party? Because our sheriffs are only loyal to one party.
Okay, and let me be, and I wasn't trying to influence you. Would you prefer to keep your position as on the bill? And that's okay. I don't want to push you in one direction.
For the bill, thank you.
Oh, no, that's good. Thank you. And I just want to make sure we were clear on that. Thank you for your testimony. Thanks for being here. The chair calls Ed Johnson. Mr. Johnson, welcome back. You know how to do this. Introduce yourself and give us your testimony.
Good to be back. Ed Johnson, I'm here representing myself, and I'm for the bill, 1589. Try to make this short and sweet. Back in about 2006, I came for this body, House and the Senate, with tax collector assessor Paul Betancourt, where we had 300 cases of voter fraud when we were talking about photo ID. None of those cases ever were investigated. Presented before this body, no investigation. I can tell you back from 2018 to 2020, some cases that came up in Harris County. We had elected officials who led insurrections, who threw out alternate judges out of polling locations, never investigated. Had nursing home attendants that called the office and said that they were being denied food if they didn't vote a certain way for the vote harvester, never investigated. Had postal employees that were blowing the whistle on their supervisors who were destroying ballots in postal locations, never investigated. Had vote harvesters passing out, as you heard earlier, ballots and mail ballots asking people to sign and send them in, never investigated. Had multiple people voting twice, never investigated. Had early voting locations and election day locations issuing the wrong ballot style to voters. That means they're voting in the wrong districts. Mike Schofield's districts had thousands of voters who voted in his district that didn't reside there, never investigated. We need some tool to do investigations. They're not happening right now. We have serious, as you heard, offenses, and they're just not being investigated. I think this would be a great tool to do it. The other part of this is actually holding a court system that would hopefully expedite hearings. As someone that was putting together the ballot to be heard, every election we always had multiple cases in court that couldn't get their day in court. And consequently were holding up the ballot from being processed for voters. This would help expedite that, which actually helps voters be able to vote the ballot that they should be voting by expediting these court cases so they're not held up and everybody gets their day in court.
Mr. Johnson, thank you. Any questions for the witness? Thank you for being here.
Thank you so much for your time. Appreciate it.
Is there anyone else present wishing to testify on, for, or against Senate Bill 1589? Seeing none, public testimony is closed, and that bill will be left pending at this time. And for the benefit of those testifying and those working through the process, we continue to hear the bills that were set for today. We may not be able to get through all of them before the Senate is in session, and if need to be, we'll come back and also to vote on some pending business. We'll continue to move through the agenda. At this time, the chair lays out Senate Bill 2202 by Senator Creighton. That bill's laid out, and we're going to leave that pending at this time. And the chair now lays out Senate Joint Resolution 51. Senate Joint Resolution 51, and we recognize Senator Creighton to explain the measure. Senator.
Thank you,
We'll
Mr.
jump
Chairman.
on SJR 51, Senator. It's hard to
SJR
see you through
51.
this glass. I'm sorry. Go ahead.
Thank you, Mr. Chairman. Members, in August of 2020, the Harris County Clerk announced that their office planned to mail an application for an absentee ballot to every registered voter in the county, regardless of whether the individual voter requested an application or whether the voter was eligible to vote absentee. The Texas Supreme Court twice blocked Harris County from carrying out this plan. Voting by absentee ballot is a privilege exercised wholly outside the traditional safeguards of the polling place. And voting by absentee ballot must be carefully regulated to prevent overzealous solicitation of absent electors who may prefer not to participate in an election, and to prevent undue influence on an absent elector to vote for or against a candidate or to cast a particular vote in an election. SJR 51 gives the Texas voters an opportunity to put this practice to rest through a constitutional amendment, which would be voted on in the upcoming November election. Thank you, Mr. Chairman and members. This is consistent with a provision, an actual constitutional provision with its wording that the state of Michigan has in its constitution. Thank you, Mr. Chairman and members.
Senator Creighton, thank you. Members, any questions for the author? Very good. We'll open public testimony, and we're going to be looking for Robert Green, for Susan Carranza, for James Slattery, for Valerie DeBille. We also have Keith Ingram here as a resource witness. Senator Creighton, do you or many committee members need the resource witness at this point? Very good. So we'll open public testimony and call Robert L. Green. We're also going to be looking for Susan Carranza, James Slattery, and Valerie DeBille. So if I called your name, please make your way down to the Senate chamber. And if you're wishing to testify on, for, or against Senate Joint Resolution 51, please register outside the chamber and come on in.
Getting exercise going up and down the stairs.
No, it's good. Mr. Green, welcome back. Get situated there. Get your papers ready. And
getting too old for this stuff.
Yeah, you and me both. Introduce yourself. Give us your testimony. Welcome back.
My name is Robert L. Green. I am here as chairman of the Travis County Republican Party Election Integrity Committee in favor of this bill. As it applies to just about all of the election integrity bills that you're going to hear here and are being heard over in the House, without any penalties for violations, what good is any law? Because it just, if people who are running an election can just say, hey, go ahead, sue me, and you have to leave, which I had to do once at Travis County elections when I was the alternate judge. They told me to go outside and watch the flash drives being brought in. I couldn't stay inside Central Count and watch what was going on simply because I asked to be able to see the screen on which they were counting votes. But What I'd like to see with this bill is not just the absentee ballots, but any ballot that is applied for by mail has to be requested. That is the only way. Otherwise, you get these mass mail-outs of applications for ballots, and who knows what happens to them from that point on. They can be modified, they can be tossed away, they can be forged. And we want our public to be confident in not just that the election is being carried out in a proper, fair, transparent manner, but they have to feel confident in the accuracy of the vote. And that's where we stand today. So it should be a consideration for any bill that you hear here today or that is heard in any other committee around the Capitol. Thank you. If you have any questions, I'll be happy to answer them.
Mr. Green, thanks for your testimony. Senators, any questions for Mr. Green? Thank you for being here.
Thank you.
The chair calls Susan Carranza. Ms. Carranza, welcome back. We'll get that space prepared for you. Welcome, introduce yourself, and give us your testimony when you get set up there.
Thank you. I'm Susanna Carranza, testifying on my own behalf, and I oppose the Resolution 51. Thanks for the opportunity to be here yet again. The proposed constitutional amendment removes any discretion from officials to handle situations when vote by mail would be the safest option, such as we had in a pandemic or any other emergency situations. The amendment broad language does not even allow this for distribution to voters that automatically qualify, such as by age. And it's really easy to identify them because their voter records will say their age. So we really should strive to make voting easier and safer to all eligible voters, and this puts way too many restrictions. I urge you to oppose this resolution. Thank you.
Thank you, Ms. Carranza. Senators, any questions for the witness? Thank you for being here. The chair calls James Slattery. There he is. Ms. Slattery, welcome back. We'll get you set up there, and we're going to be looking for Valerie DeBill after Mr. Slattery. Ms. Slattery, have a seat, and you know how to do this. Introduce yourself and give us your testimony. Welcome back.
Thank you. James Slattery, representing the Texas Civil Rights Project, testifying against Resolution 51. Texas is already the hardest place to vote in the entire country, in part because it has among the most restrictive vote-by-mail laws in the United States. At the start of 2020, Texas was one of only 16 states that denied voters the right to cast a mail-in ballot unless they had one of a narrow set of government-approved reasons specified in the election code. When the coronavirus struck Texas, it remained one of just 6 states refusing to expand mail-in voting during the pandemic. It is unbelievable, then, that Resolution 51 seeks to make voting by mail in Texas even harder than it already is by writing into the Constitution a prohibition on government employees distributing an official application form for an absentee ballot to a person unless the person has requested the distribution. This prohibition is so sweeping that it would prohibit counties from even passively distributing application forms, such as leaving them out on a table for voters to pick up or posting them on a county website. That makes this proposal even more restrictive than the notorious law recently passed in Georgia, which contained an explicit exception allowing counties to post application forms online. Even if a voter comes down to a county elections office to pick up a vote-by-mail application, election officials could not hand over a form unless the voter happened to say the magic words requesting an application that the amendment requires. The committee should therefore reject this amendment for imposing yet another unnecessary and irrational burden on Texas voters.
Thanks for your testimony. Senators, any questions for the witness? Thanks for being here.
Let me.
Sorry, Senator Lucio. I didn't see your mic there. Go ahead, Senator.
Thank you for your testimony. You know, I've seen it all, I guess, since 1987. And it's just beyond my comprehension at times where we don't do everything and anything that's needed to be done that a citizen of this state would have the opportunity to vote and present in front of him, her, less hurdles to have to go over to be able to accomplish that. Do you agree with that?
Yes.
And it appears that, my dream a couple of sessions ago when we had all this technology changing our lives was that teachers could teach out of their conference room on their break, that disabled seniors could also be given the right to have the assistance they needed to be able to vote from a nursing home. No matter, what it would take. And again, I want to thank you for working so hard to make the American dream, which many people that come here for the first time, I've heard so many immigrants that are naturalized say, the first thing I want to do is be able to vote in a free election. First thing I want to do is be able to elect those that are going to be governing me. And it seems that, unfortunately, we're getting away from that, even though I know the men and women who are working on these issues, and they want, obviously, a fair election, transparency, to make sure that the letter of the law is followed. So for that reason, I appreciate them and I commend them, but we could make it a lot simpler, don't you think?
Yes.
It's just too hard to vote nowadays, so people are going to stay away. And I guess for a lot of people, that's unfortunately what some people want to see happen. Thank you for your testimony.
Thank you.
Thank you, Senator Lucio. Thank you, Ms. Slattery. The chair calls Valerie DeBill. Valerie DeBill. All right. Ms. DeBill, we'll get that spot ready for you. Welcome. Once you get situated there, introduce yourself and give us your testimony, please.
Thank you. My name is Valerie DeBill, and I'm testifying on my own behalf against the Resolution 51. During early voting and on Election Day, I volunteer as a supervisor at a Texas voter assistance hotline, and I've also helped voters at senior centers and retirement homes fill out their applications to vote by mail. While I'm not quite old enough to automatically qualify to vote by mail myself, I've spoken to and helped a significant number of people who are. The 2020 primaries, if you recall, took place in those halcyon days before COVID, so we weren't yet inundated with calls from people who wanted to know if concern about catching COVID qualified as a disability in the context of voting by mail. I point this out to make it clear that the primary period was the last election for which our call type and volume were what would be considered typical. 28% of all those hotline calls for the 2020 primary were about voting by mail. 58% of those calls were people who had voted by mail in previous years and wanted to know why they had not yet received their ballot. Most of those callers were qualified to vote by mail due to their age, but they didn't know that they had to submit a request every year. Many of the seniors that I assisted in person were also unaware that they needed to make a request annually until we showed up to help them do that. Sending unsolicited applications does no harm and can be very helpful to those qualified individuals who do not know that they must submit an application every year. The intent of this amendment, as stated, is to increase election security, but I do not see how mailing a form to voters constitutes a security issue. I agree with the bill's authors about the second issue raised in the author's intent statement, which is the volume of paper discarded by people for whom the application goes unused.
Thank you, Ms. DeBill. Senators, any questions for the witness? Thank you for being here.
Thank you.
Is there anyone else present wishing to testify on, for, or against Senate Joint Resolution 51? Seeing none, public testimony is closed, and the bill be left pending at this time. The chair now lays out Senate Bill 1509. Senate Bill 1509, and recognizes its author, Senator Creighton, to explain the measure. Senator.
Thank you, Mr. Chairman. Members, I do have a substitute for Senate Bill 1509.
Senator Lucio sends up the committee substitute, Senate Bill 1509. Chair recognizes Senator Creighton to explain the substitute.
Mr. Chairman, members, in the lead up to the 2020 election, many states dramatically expanded absentee voting. Millions of Texans feel anxiety about the security of absentee voting, and Senate Bill 1509 provides an avenue for Texas to address those fears without placing a large burden on eligible absentee voters. Senate Bill 1509 requires a space for the voter's driver's license or DPS-issued identification number to be included on an absentee ballot application form and absentee ballot. If a voter does not have a DPS-issued identification card, then the last 4 digits of the voter's Social Security card can be used in that space. Voters already must provide their DPS-issued identification card of the last 4 digits of their Social Security number when registering to vote in the state of Texas. Currently, voters are required to print an absentee ballot application form from the Secretary of State's office and transmit it to their county's election clerk. When the county or the election clerk receives an absentee ballot application, the clerk will compare the identification number or the last 4 digits of the voter's social to the records from the voter's registration. If the numbers match, the voter will be mailed an absentee ballot. If the clerk rejects the application, the clerk is already statutorily required to inform the voter of why the application was rejected, and if the clerk accepts the application, the voter mails the clerk a ballot. When the voter completes their absentee ballot, they will also enter their identification number or the last 4 digits of their social and mail in their ballot. When the ballot is received by the early voting board in a county, the board shall compare those numbers to the voter registration information, and if the numbers match, the ballot will be counted. If not, it will be rejected. Members, Senate Bill 1509 maximizes security while minimizing the burden on voters, and I believe this bill will increase the overall trust that Texans have in our voting system. Thank you, Mr. Chairman and members. And again, the difference, Mr. Chairman, in the substitute and the original file version is the driver's license number or the last 4 digits of the social, whereas in the original file measure, the ID itself and a copy of the ID was required to be included.
Thank you, Senator Creighton. Senators, any questions for the author? Senator Lucio.
I think we're heading down the right path here in terms of making sure that every voter has some type of voter ID. I support that. I support that. Okay, I can hear myself loud and clear. I'm wondering though, if we have a system set up where it facilitates the voter to be able to receive something. For example, right now in your voter registration card that is issued to you, there's no ID photo or anything on that card, correct?
That's right.
Has any thought been given to putting a photo on that card as well, or allowing a photo presented by me when I renew my voter registration, or when I turn the voting age and I go for the first time to apply for a voter registration card, to present with our technology today. I'm sure there's a machine that could print the voter registration card along with a photo, just like a driver's license. Isn't that true?
It's true, Senator Lucio, and it's not within the scope of this bill to address the voter registration card, but in talking about the merit behind a photo ID, the DPS issued identification card and/or the Social Security number has to be used to register to vote anyway.
But you are talking about Social Security, you're talking about driver's license number, you're talking about other forms of ID.
Sure.
What I'm trying to do is just, in conversation, describe what the possibilities are so that we won't have to worry about driver's license or Social Security numbers. Once I go and apply for a voter registration card, I have to bring my documents to prove that I am a citizen, where I live, and so on and so forth. And once you have that voter registration card with your ID on it, it should work out where that's all you're going to need anyway in the future without having to look at other forms of IDs. I'm just trying to simplify the system.
I think there's a lot of merit behind that proposal. It's not within the scope of the bill, but yes, if we talked about a specific voter ID card, as long as the DPS was involved in the creation of that card, as long as the identification number from the DPS that is on each of our driver's licenses was on that card, and as long as a reference to the last 4 digits of the Social Security number was on that card, that along with a photo ID would be similar to what we're pushing for. But right now, those are more requirements than we're talking about within the scope of the bill. We can continue to work towards some of your ideas there. I don't know if you filed a specific bill on that or not, or if you've had a hearing, but for our purposes today, we're talking about bringing the absentee ballot and the requirements of authenticity behind that ballot in line with requirements that are already in place for a voter to be identified if they show up at the polls. Nothing more, nothing less.
And I understand exactly what you got in your bill. All I'm saying is that we need to think ahead and make it even simpler. I spoke a little while ago about making sure we kind of streamline things so that we can allow citizens who are citizens the right to vote. And I certainly appreciate what you're trying to do to make sure it brings complete transparency and making sure that this voter has whatever documents are necessary by law to receive their absentee ballot. I appreciate that.
And we have, especially with the substitute, we have made this bill much simpler. So if a voter in Texas is registered to vote, they would have already had to submit their DPS identification number and/or the last 4 digits of their social. This just requires what they've already done, the information they've already submitted and been approved for, to be written into a space on their absentee ballot if they so choose to use an absentee ballot and if they are an eligible voter for absentee ballots.
Thank you, Senator Creighton.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Lucio. Senator Creighton, any other questions for the author, members? All right, we'll open public testimony. And the chair calls, invited testimony first. Chair calls Chuck DeVore. Honorable Chuck DeVore for Senate Bill 1509. Welcome, introduce yourself, tell us who you represent, and give us your testimony.
Thank you, Mr. Chairman and members. My name is Chuck DeVore, and I'm here representing the Texas Public Policy Foundation, testifying in favor of Senate Bill 1509. Texas is an excuse-required state to vote by mail, and yet what we've seen in the last 2 presidential election cycles is that the share of votes by mail have increased substantially. In 2012, we saw about 204,000 mail-in ballots. This last go-around, it was about 1 million. If you go back to 2010, about 1.8% of all the votes cast were by mail, and this last go-around, it was about 9%. And why is that important? That's important because Texas is a state that requires voter ID to vote. Now, obviously, if you have difficulty getting voter ID, you can file the reasonable impediment declaration, but most people who vote in person do provide identification. When you vote by mail, though, you simply provide a signature, and then you have a subjective analysis with either the early voting ballot board or with the signature verification committee. And as we know, in Texas code, if the early voting ballot board rejects a voter's ballot, there's a report that ends up getting sent up to the Attorney General's office within 30 days, and the voter, of course, has to be notified within 10 days. Interestingly enough, there is no mirror image requirement that if, for example, a large number of ballots go through and one of the minority members of the early voting ballot board protests because the signatures look somewhat suspicious, there is no report that ends up getting made that is sent up to the Attorney General's office. And so rather than live with this ambiguity and live with this subjectiveness, this bill, as modified with the committee substitute, which is a very good change to the bill, simply requires that voters affix some of their identification documents that would have otherwise been presented had they gone to vote in person. And therefore, what this bill does is it prevents this long-term shift that we have seen in Texas going from in-person voting to voting by mail. It prevents that from essentially degrading the level of security and integrity that this legislature has seen fit to put into place with in-person voting. And for that reason, I think it's a very important measure to bring by-mail voting up to the same standards of election integrity that we see with in-person voting. Thank you, Mr. Chairman and members. And with that, if there are any questions, I'd certainly be delighted. Oh, one more thing. Dallas Morning News this morning, I almost forgot. They had a very interesting poll that they published, had favorability ratings for a lot of the major elected officials around the state, but they also asked the question about whether or not additional requirements should be needed or levied on mail-in ballots to augment election integrity. And interestingly enough, Dallas Morning News, this is not a TPPF poll, although our poll found something similar, even with better numbers. Dallas Morning News this morning, 60% of Texans support measures that would improve election integrity for mail-in ballots, and only 18% oppose. So I think we see some fairly strong consensus among Texans understanding that it's a good thing to have enhanced election integrity with mail-in ballots. Thank you, Mr. Chairman.
Thank you for your testimony. Senator, is there any questions for the witness? Senator Lucio.
Thank you for your testimony. I think all you say has merit. However, what you don't take into consideration, because I don't think you've been in the neighborhoods that some of us have, where you can find out that modern technology doesn't exist. So to a lot of voters who are citizens, bona fide citizens of this state, it's going to make it very difficult for them to be able to come up with the requirements leading to a photocopy of themselves. I think what we should focus on is, from the very beginning, I have my birth certificate and I have all my documents at the age that I turn of voting age, and I go down to the courthouse to register to vote, or there's a registrar that is registering people, that I present those documents and that I become a bona fide voter. And that if we're going to go into this voter ID requirement and all, that the state, not the voter, would have to come up with having to provide, the documents that are needed. Let the state come up. DPS is a wonderful agency, I agree. For those that have driver's license, no problem. For those that do not choose to get their driver's license, but depend on family members to drive them, then we need to come up with a system where people who don't have the means of providing these documents with a photo of some kind for ID have another way of making sure that they're not fraudulent in the system. I don't care. I can't stand voter fraud, believe me. I don't want that to ever be the case. But no one has presented to me today any good reason in any fraud that might have been taking place that's out of control to be able to come to this point. I would rather us do something that will connect, just like we're trying to connect with our children right now to get them back in school, connect with the voters, make sure we get whatever documents we're looking for, and then ourselves provide those documents and set up a system where people can vote without having to go through another hurdle. There's not enough hurdles out there already, so that's my position on it anyway.
Thank you, Senator. Mr. Ford, let me ask something as well. I'm looking at the substitute, and I know that when this discussion came up about writing the driver license number on the application, and then on the envelope, when you return your ballot, there were concerns about security. But I know Senator Creighton has put in here on page 4, it says the carrier envelope must include a space that is hidden from view when the envelope is sealed for the voter to enter the following information. So then, as I read this, and as Senator Creighton explained, the voter would enter this information, but then when they seal the envelope, it would not be visible to folks who see it, if it's going through the mail or anything like that. Is that how you read it?
Yes, Mr. Chairman, that's how I read it. And my understanding is as well, if the individual does not have the driver's license, there are alternative numbers that might be used that would indicate that that is in fact who is casting the ballot.
That's right. They'd get the driver license number, state ID number, or the last 4 of the social. But whatever that information was, as I read it, it would be protected from view. No one would see that until it reached its location, and the ballot board was looking and verifying the numbers. Is that how you read it?
Yes, Mr. Chairman, and because of the committee substitute and the substantial changes made, it certainly goes a long way toward addressing some of the concerns I've heard previously expressed before this body and the House as well regarding the potential of imposing some sort of a cost on voters. This removes any of that consideration, at least as one of the arguments against the measure.
So to the extent that many of us might have concerns that a voter is being asked to go through an extra burden, go make a photocopy, maybe I don't have a printer, under the committee substitute, the voter need only write in their state ID number, driver license number, or last 4 digits of social. So obviously no cost or burden to that. Is that how you read it?
Yes, Mr. Chairman, absolutely. And I think as well it enhances the ability of making sure that the right votes are going to be accepted and not arbitrarily rejected. It really strengthens the confirmation that the person who is casting that vote is in fact the citizen who is allowed to cast that vote. One of the things that I thought was very interesting in the research that I've conducted over the last few months to prepare for this session was there was an ABC News survey of mail-in ballots from around the nation that was conducted in the 2016 and 2018 election. Nationwide, as I recall, a little over 0.6% of ballots nationwide were rejected due to signature mismatch. In Texas, that number was about half that. It was about 0.32%, if memory serves, in those 2 election cycles, 2016 and 2018. However, there was really significant variation in certain regions in Texas, especially down along the Rio Grande Valley, where you had counties that either rejected no mail-in ballots at all, or they had rejection rates some 7 to, I think it was actually closer to 13 times the Texas average. And so what was happening here was likely where you had certain partisan configurations. In this case, it would be, if you will, the machine and the county that was rejecting large numbers of ballots from what was likely the opposing side, which is why you saw 14 times the rejection rate. Now, these were individuals that were probably having their votes disenfranchised in some of these instances. And I think that this measure goes a way toward addressing that issue of having kind of a subjective signature validation. It adds another layer of certainty that this, in fact, is a citizen who is legitimately casting their ballot. And it just seems to me a very common sense measure that would greatly strengthen not only the integrity of Texas elections, but also likely increase the likelihood that citizens get their ballots actually cast and counted.
Thank you for your testimony. Any other questions, members?
No, just to respond to that, and very eloquently presented, I hope that's the case. I'm going to monitor it very closely. I hope that's the case, because this is going to pass, and I'm going to make it, I am going to do everything I can to work with local officials and also inform the general public specifically what is expected of them. And I really hope that it doesn't cause any issues where people will stay away from the polls for whatever reason. But if they stay away, I hope it's because they're not citizens and they shouldn't be voting. I don't care to support any kind of action that would open the polls for anyone that is not qualified to vote in our elections. But at the same time, I want to make sure that whatever we do pass, it's more of a benefit than a handicap when it comes to the people out there who need somebody to give them the support and the help they need to better understand what is expected of them. I surely hope that that's the case, because if people think that things are getting too comprehensive and too hard for them to follow, they're just going to stay away from the polls. And that's something that we don't want to see. Thank you.
No, that's right, Senator Lucio. Thank you for that. Any other questions for the witness? Thanks for being here.
Thank you, Mr. Chairman and members.
As we open public testimony, the chair calls David Weinberg. David Weinberg, and we're going to be looking next for Susan Carranza, Joshua Houston, Valerie DeBille, and David Griggs. So if you're not in the Senate chamber, please, Ms. Carranza, Susanna Carranza, Joshua Houston, Valerie DeBille, and David Griggs, please make your way down here. Mr. Weinberg, welcome. Introduce yourself. Tell us who you represent. Give us your testimony.
Thank you, Chairman and members. My name is David Weinberg. I represent the Brennan Center for Justice, and we're here today opposing Senate Bill 1509. First of all, very quickly, we are appreciative that the committee substitute took out the requirement to make a photocopy of an ID, which we would have seen as a poll tax on the elderly and the disabled who lacked access to a printer, as well as create other legal problems with people going to the same copy shop to make copies of their IDs. However, we still have problems with the bill. As we've heard testimony earlier today, Texas is already the most onerous place to vote in the country, and we have very limited sort of ways in which people can vote by mail, and this is adding another layer. Now, it may seem sort of common sense that, okay, all we're doing is just asking people to put down their driver's license number, their social security number. That's no big deal. But it bears mentioning that, well, that is adding another layer to folks who've voted by mail for years and years and years to do something else. But it bears mentioning that with all of the election legislation going through this body, this session, we cannot look at these things in a vacuum. So not only would we have this new requirement on this form for the individual, but let's say grandma's like, what am I doing? I've got to write down my social now. Anyone assisting that person under Senate Bill 7 and House Bill 6 would also have to fill out a new form about their assisting the voter. And particularly in House Bill 6, if that person is not a family member and knowingly does not fill out that form, they are staring down a state jail felony under that particular legislation. So we have to be very careful about, in sum total, what we are doing here this session with voting. Thank you very much.
Thanks for your testimony. Members, any questions for the witness? Thank you for being here. The chair calls Susanna Carranza. Ms. Carranza, make it back down. While we're giving her some time, the chair calls Joshua Houston. Joshua Houston. Ms. Houston, welcome back. You know how to do this. Have a seat, get situated there, and give us your testimony. Welcome.
Thank you, Chairman. My name is Joshua Houston. I'm the Advocacy Director for Texas Impact. We are opposed to the as-filed version of Senate Bill 1509 because of the access to the photocopier issue. That should not be a prerequisite for the right to vote by mail. However, we have heard the layout, and what we think we heard is that it's changing from and to or, so that you can have, you don't need a photocopy, you can handwrite it, and that you can do a driver's license or social security number. And if we heard that correctly, we appreciate the hard work of Senator Creighton on this. We have not had an opportunity to read the sub. But if it is similar to the work done on House Bill 2478 and the good work that Representative Harris did over in the committee in the House, then it makes the bill much better and should not hurt folks like my 98-year-old grandfather that's never owned a computer in his life and cannot physically get to a FedEx or wherever to make copies of his 25-year-old expired license. We do not know, and we're seeking to find out how many citizens would not have a Social Security number, but we suspect that's a pretty low number. We do know how many forget to sign the carrier envelope, and it is a very low number. We open record requested acceptance and rejection rates for the 30 largest counties dating back for the last 3 election cycles. And to give you some idea, Bexar County, it's about 14 people out of 45,000 ballots. That was the 2018 general election. It was 19 people forgot to sign it out of 42,000 ballots in the 2016 general. You get to a mid-sized county like Jefferson, it's 6 in 2018, 4 in 2016. So this significantly cuts down on the number of folks like my grandfather that would have been unable to access a photocopier. So we thank the Senator for his work, we thank the committee for the work, and we look forward to working with you.
Houston, thank you for your testimony. And so we understand your position was against based on the file version, and I'm not trying to influence that. Is that still, for now, until you take a closer look, or you still want to keep that position?
We just want to take a closer look at who might not have a Social Security number, and then we need to talk to the board about that a little bit. But
no problem at all. Just make sure we're clear. So if there's any questions for Mr. Houston, and thank you for working with the author and working through the process as you do. Thank you very much.
Thank
you. The chair calls Valerie DeBill. Ms. DeBill, come on down. Welcome back. Get set up there and introduce yourself to us again and give us your testimony. Welcome back.
That substitute really kind of shot a lot of my objections out. My name is Valerie DeBill, and I'm testifying on my own behalf against 1509. In the 2019-2020 election cycle, I personally registered almost 1,000 Texans to vote. And in the process, I answered hundreds, if not thousands, of questions. I also, as I mentioned earlier, work at the hotline during an election period. And so I've had a great deal of interaction with voters and the kinds of things that are confusing to them as a result of our laws. And as somebody mentioned earlier, a patchwork, that they've been pieced together. And sometimes they aren't really easy to find out. And so every time we add a step, every time we add something, we're increasing the burden and we're increasing the level of confusion on the part of the voter. And my philosophy when I'm interacting with voters is that the better a voter feels about going into the voting booth, casting their ballot, the more likely they are to actually do it. If they're confident that they know what they're doing, that they're not going to have a problem, that they're not going to, incur some sort of issue, they're much more likely to actually do it. And if they do all of that successfully, they're much more likely to do it again. And so we try to give them as much information as possible without overwhelming them. And that, in a nutshell, is, I think, the issue with a lot of the election bills going right now, is that each one of them just adds another level of confusion. Is this true? Is this not? For that reason, I appreciate that a lot of the things that I objected to were removed. That's great. But early voting clerks already verify an applicant's information when they get the application, which, by the way, you do not have to present any ID to actually register to vote. You just have to present it when you vote. But we don't need additional layers. It's just, this is not a widespread problem that needs a solution. Thank you.
Mr. Bill, thank you. Senators, any questions for the witness? Thank you very much for your testimony. Chair calls David Griggs. Mr. Griggs, there you are. Welcome back. Come on down, get situated, and introduce yourself. Tell us who you represent. Give us your testimony.
Thank you, Mr. Chairman. David Griggs, representing the Lone Star chapter of the Sierra Club as its political chair, as well as myself. I'm from Dallas, and I'm glad to be back to testify against another bill, this one being 1509. I do want to say, as other speakers have, that Senator Lucio's substitute does address one of the major concerns that many of us have had. So thank you for doing that. Having said that, though, it still does present extra burdens on the part of the voter. Maybe not one that's insurmountable, but certainly an extra burden on the voter. One of the questions that I have is that the indications are that the clerk shall reject the application if this information is not correct. Has there been any consideration to putting a provision in or considering that one notify the voter if something is missing or not complete rather than an absolute rejection? That's a concern that I have. And then finally, I'm also concerned about the criminal penalties of this and other bills, just like David Weinberg of the Brennan Center mentioned earlier, a couple of speakers ago. If you take this with the criminal penalties that are being set forth in Senate Bill 7 and other areas, I think it does create a potential concern on the part for voters for participating in the system. So having said that, I still feel that I would be opposed to this Senate Bill 1509.
Mr. Griggs, thanks for your testimony, and I'll note that I know there's so many bills moving through the process, but when you get a chance, take a look at Senate Bill 1018 by Senator Saffarini, passed out of here almost unanimously, and it provides that cure process that's come up a number of times. So I think you'll like that. I think we're all going to like that. But any questions for Mr. Griggs? Thank you for your testimony.
Thank you.
And the chair calls Susan Carranza. Carranza has testified a couple of times. We may have lost her. Anyone else wishing to testify on, for, or against Senate Bill 1509? Seeing none, we'll close public testimony. Senate Bill 1509 left pending at this time. The chair now lays out Senate Bill 1508 and recognizes its author, Senator Creighton, to explain the measure. Senator Creighton.
Mr. Chairman, there is a substitute.
Senator Lucio sends up the committee's substitute. Senate Bill 1508 recognizes Senator Creighton to explain the measure.
Mr. Chairman, members, the committee substitute to Senate Bill 1508 creates an election integrity division within the Office of the Texas Attorney General to safeguard the integrity of elections and ensure public confidence in the electoral process and to investigate and prosecute election fraud offenses. In order to ensure the Texas Attorney General's office has the information it needs to investigate and prosecute voter fraud, this bill requires a law enforcement agency in the state to assist in investigations conducted by the Election Integrity Division. It also requires election officials and political subdivisions to promptly provide election records and other information pertinent to an investigation by the Election Integrity Division. Currently, there is no guarantee that the Office of the Attorney General will investigate and prosecute claims of voter fraud within the state. Regardless of who is elected as the Attorney General of the state of Texas, Texans want to know that voter fraud will be investigated and prosecuted. The committee substitute for Senate Bill 1508 accomplishes that. The substitute, Mr. Chairman, clarifies the duties of law enforcement and local government to assist with these investigations. Thank you, Mr. Chairman and members.
Senator Graydon, thank you. Members, any questions for the author? Senator Luzio.
We all know the Secretary of State oversees elections in the state, and I'm confident that Attorney Generals, present and future, would do a good job. I'm not questioning the Attorney General's office. Why not work this issue out of the state of Secretary of State's office, and if they find any kind of evidence to that effect, they can always send it to the Attorney General. I think it'd be, more, how can I say, more central, because they're already in the business of overseeing the elections in this state, don't you think?
They are, Senator Lucio, but as you know, with the Child Support Division that I used to work for the Texas AG, with consumer protection, certain environmental concerns, there are, and we have obviously shown precedent in the past to prioritize what resources are allocated in which direction. And so what we've seen in other states around the country, and certainly from requests from our current AG, is that resources are needed in the Attorney General's office. And right now, yes, they could maybe dedicate 2 to 3 attorneys to these types of referrals from the Secretary of State, but that's not nearly enough for the size of our state. And
that's what I was going to say. I don't think that's anywhere close to probably setting up a division to address over 30 million people that live in this state. Not all of them vote, obviously, but you can imagine how many elections are going on. Why wouldn't the Secretary of State be the agency to oversee that if that's one of their main functions? I could live with either one. But I think the Secretary of State is one that, did you look at that at all?
Well, the Secretary of State's role would certainly not change, and their role remains as important as ever. But with over 508 open election fraud counts and 200 cases, the fact that it takes up to a year to develop a case and pursue it for prosecution, I think it's not only appropriate for the state's attorney to oversee that effort from there forward. It's very much
tell me how
should
this
be
would
required.
Work. How this would work, Senator, would local election officials go straight to the Attorney General's office with a complaint or a request for the Attorney General to look into voter fraud?
It would work exactly as it does today. The only thing that we would be doing in this legislation would be establishing a division to show that the legislature's intent for the state's attorney is to not only pursue prosecution of election fraud, but that we would also provide direction. We would provide resources, especially from the financial side, as we have current requests pending to this legislature in the Senate and the House, and our budget writers in each chamber from the AG himself to make sure that division is funded properly. And from local to state, it would work exactly as it currently does.
Well, that's where I was going with my questioning. It appears that the Secretary of State already involved in this function and taking in voter fraud complaints, etc., and then following up in addressing that. with what they have. This would set up, obviously, another division within the Attorney General's office. Do you know how much that would cost to be able to look at it, in the right perspective? Another one, what's the fiscal note on it is what I'm trying to say.
That would be something that you and I and others, especially the chair and Senate Finance, would have to, to consider as we work out not only the budget as it stands in the process now, but it would also have to do with conference committee and what we decide to negotiate with the House on the differences in their budget. So at this time, there's not a fiscal implication to the state anticipated. This would just create the division itself.
So we're trying to create a division inside the Attorney General's office, and there's no reference to how much it would cost to run this new department within the agency. It's just creating the system.
That's correct. They'd have to work within their current budget within this biennium, as we just discussed, and any expansion for funding or resources would be taken up in a subsequent budget.
Thank you, Mr. Chairman. Thank you, Senator.
Thank you, Senator Lucio. Thank you, Mr. Chairman, members.
Thank you, Senator Lucio. Senator Creighton, any other questions for the author? Very good. We'll open up testimony, and the chair calls Jonathan White from the Office of the Attorney General. Mr. White, welcome. Introduce yourself. Tell us who you represent.
Good afternoon, Committee. Jonathan White. I'm the Section Chief of the Election Fraud Section of the Special Prosecutions Division at the Attorney General's Office.
Thank you, Mr. White. And in the course of your work, you just described your title. Does your work involve an investigation of election matters?
Yeah, we do have a separate division, Criminal Investigations Division, that supplies investigative resources in their election fraud unit, and we coordinate closely with them.
Have you had the opportunity to take a look at the bill that's before the committee, Senate Bill 1508?
Yes, sir, we have.
How would Senate Bill 1508 affect operations, organization, Attorney General's office, and handling of these cases?
I think without additional funding, it's largely organizational in that we would just combine units in two separate divisions into one division to work under one roof. And so we would unite the prosecutors with the investigators under a single division, and that would basically be the extent of it at this point.
And based on your experience, would that provide efficiencies, more convenient, make it easier to thoroughly investigate and to get to justice in these cases, or do you have an opinion on that?
I think in having one chain of command, certainly there could be some efficiencies with further integrating these two sections. Yes, sir.
And Senator Creighton, do you have any questions for the resource witness? Okay. Senator Lucio.
So you're telling us here today that you're already operating and doing what this legislation would actually do in its creation. So if you're doing exactly what this legislation is being established to do, wouldn't we just have to work with you to make sure you have the resources, the funds necessary to do what you're doing, and maybe hire more individuals to beef it up, so to speak?
I think so, Senator. I think that would be the approach, and what this bill would force us to do would be to organize under a single division, and it would lock in that division as a division of the Attorney General's office going forward.
So we really don't need legislation to establish what you're already doing. I would gladly work to make sure you have the funds that are necessary, especially if there's fraud. Believe me, it's not a partisan issue for me. It is an issue that I take very seriously. Don't want to see it happen, but I want to make sure we do have a system that you're not responsible for, obviously, looking at. We are, as legislators, and also election officials around the state, the Secretary of State's office, we all work to try to set up a system we're policymakers to be able to seek fair elections that our voters can obviously be involved with without having to go through so many loopholes and go over too many hurdles. So I thank you for your testimony.
Thank you, Senator. I appreciate it.
Thank you.
Thank you, Senator Lucio. Any other questions for the witness? Thank you for being here. Thanks for your testimony.
Thank you, Chairman.
The chair calls James Slattery. Mr. Slattery, he's probably around here. And while he's making his way down, we're also going to be looking for Mr. Griggs. I see Mr. Griggs is in the chamber. We're going to let you cut in front of Mr. Slattery. Come on down. I should have warned y'all. Mr. Griggs, come on back. Mr. Slattery, take your time. Don't fall. And Mr. Griggs, have a seat. Get situated there. We're, of course, on Senate Bill 1508. Welcome back. Introduce yourself. Tell us who you represent. Give us your testimony.
Thank you, Mr. Chairman. David Griggs, representing the Lone Star chapter of the Sierra Club. And I promise this is the last bill that I'm going to be testifying on today, in this committee anyway. But thank you for that opportunity and the warmth that you've provided to all of us as we've spoken to these bills today and in the past. I am opposed to this bill because, in a way, I think Senator Lucio said it, we don't need this. I mean, the Attorney General already does this type of thing. And so why do we need to put more emphasis on it and potentially create a bureaucracy to use to try to go after these types of cases in the future? It just seems to be unnecessary, an unnecessary centralization of power to create a division within an agency that already has the jurisdiction to do what they're doing. I fear that it could be used in a political way, potentially a highly partisan political way, and an attorney general could claim to get away with this type of thing just because he can, because it's there in a legislation. So I would encourage you not to put forward this legislation. Perhaps where Senator Lucio was going in some sort of an arrangement or understanding or more funding or however you want to do it, but I just don't think that we need this bill. And let me end by just saying this, because I was waiting until the right opportunity to do this. The Houston Chronicle laid out some interesting facts in their editorial this weekend called The Big Lie. I don't know if you saw it or not, but it talked about the 174 cases that had been brought in the last 15 years since these investigations for fraud were brought about. Only 174 out of 94 million votes. That's 0.0001%, 1/10,000th of a percent. And it's more likely that you would get struck by lightning than you would have a successful fraud prosecution in Texas. And finally, I'll just end with this. I like the analogy that the editorial used to Major League Baseball. It's just as likely that you would find a situation where you have 2 no-hitters by the same pitcher in a row than you would have voter fraud in Texas. I thought that was a very apt analogy for this, and I think it applies to several of these bills. Thank you.
Mr. Griggs, thank you. Senator Lucio.
Thank you for your testimony, but I do want to make it clear for those listening that Senator Creighton really is a good friend of mine. I like him. He's quite a gentleman. I've gotten to really respect his hard work. And then sitting here listening and trying to figure out what's happening, I really think that he is sincere in terms of making sure that someone would be responsible somewhere in state government to be able to address voter fraud if there was any. And I respect that. I really do. But I also, what you had to say is meaningful. I haven't seen it to a degree where I'm scared to death of it. I'm really concerned about people staying away from voting and not participating because of so many laws that might be taking place that they're hearing about and just say, I don't want to deal with that anymore. If I make a mistake, I'm scared that somebody's going to put me in jail for an honest mistake of some kind. We don't want anyone in our state to feel that way. But again, in closing, I think Senator Creighton, we don't know what the future holds in store, what attorney generals will serve someday, what secretary of states will serve, what governors will serve. But I think I think what his goal is, and correct me if I'm wrong, Senator, of wherever you are back here, is we need to have a system we can all agree to and be proud of and make sense of when we pass anything in this chamber that will bring a better system for the citizens of this state. But I thank you for the work you do, sir. Thank you very much.
Thank you, Senator. Thank you, Mr. Chairman. Thank you, committee.
Thank you, Mr. Griggs. Thank you, Senator Lucio. The chair calls James Slattery. Mr. Slattery. All right. Ms. Slattery, welcome back. Get situated there, then introduce yourself, tell us who you represent, and give us your testimony.
Thank you. James Slattery, representing the Texas Civil Rights Project, testifying against 1508. Picking up on the discussion Senator Lucio had earlier, either this bill is cosmetic and does nothing, thereby costing nothing, as the fiscal note suggests, or it is a true reorganization of the Attorney General's office, presenting a potentially enormous cost to a taxpayer compared with the apparent scale of the problem. A recent investigation by the Houston Chronicle revealed that the 17 law enforcement sergeants and the 4 prosecutors assigned to the current Election Integrity Unit resolved only 16 prosecutions in 2020, half as many as in 2018, despite devoting more staff and staff time to looking for voter fraud. This is no anomaly. Other reviews of the Election Integrity Unit's record have shown that despite aggressive efforts to find voter fraud, the unit has largely found what even it considers are merely minor offenses, as evidenced by the fact that an overwhelming share of defendants are placed in a diversion program. And these efforts have not targeted all suspects equally. A recent analysis by the ACLU found that since Ken Paxton took office, at least 72% of the Election Integrity Unit's prosecutions appear to have been against Black and Latinx individuals. Seen in that context, there are much better ways that Texas could use this money and resources to make our elections both more accessible and more secure. For instance, Texas could implement online voter registration, as 40 other states have now done, which would make our voter rolls more accurate by allowing voters to quickly update their information in real time. It could also provide substantial new funding for our chronically underfunded county election offices, which they could use to upgrade voting machines and bolster the recruitment and training of poll workers. Thank you.
Sorry, thanks for your testimony. That was exactly 2 minutes to the second, man. Hey, good work. Thanks for the information. So if there's any questions for Mr. Slattery, thank you for being here.
Thank you.
The chair, now we'll ask if there's anyone else present wishing to testify on, for, or against Senate Bill 1508. Oh, come on down, Mr. Green. We'll find you in here. We've got your information. Maybe we had you. Hold on one second while you're getting situated. Is he in there at all? Yes, yeah. Very good. We've got you. We showed you on the bill, but not testifying. We'll switch that to testifying.
Thank you.
Welcome back. Introduce yourself. Tell us who you represent, even though we know, and give us your testimony. Thanks.
Appreciate it. My name is Robert L. Green. I represent the Travis County Republican Party Election Integrity Committee, and I'm here testifying in favor of this bill. Once again, if there's no punishment for violations, what benefit is any law? I'd like to talk a little bit about this the Attorney General's office, and I think that they have talked about the fact that it operates a little bit like an emergency response situation, that they have a fluidity within their department. They can take investigators, and they can take prosecutors, and they can move them around within their offices as necessary, so that at certain times of the year, like during elections, they can bring people into that from other divisions, and it doesn't really cost them anything. It just changes the focus of their investigation or their prosecution. I'd like to read a little bit from just something recently from an article on April 6th. Election fraud prosecution at an all-time high, according to the Texas Attorney General's office. An official in Texas Attorney General's office testified during a State House hearing that the number of election fraud cases in Texas is at an all-time high. The number is higher than our historical average by a long shot, said Jonathan White, the head of the Election Fraud Agency within the Texas Attorney General's Special Prosecution Division, to the Texas House Elections Committee last week, reported in the Texan. When asked by a state lawmaker if there were trends in election fraud prosecutions, White said that we have 510 offenses pending against 43 defendants in court right now, saying it's for several reasons probably, but he didn't elaborate on the reasons for it. White also said that about 80% of those pending cases involve alleged mail-in ballot fraud, and 60% of resolved cases involved mail-in voting. The Attorney General office has prosecuted 534 election fraud cases committed by 155 people since 2005, according to the report. I think we all agree that 99.9% of the people, vote fairly, and there's not a problem. But we really have to, and this is a presumptive strike, I think, against increased voter fraud in the state. So thank you. If you have any questions, I'll answer.
Mr. Reed, thanks for your testimony. I bet you, I'm going to ask you if you've noticed this with so many of the election integrity bills that are moving through the legislature. Most of those bills are aimed not at voters, but at vote harvesters, those folks who cheat and mislead, who try to imitate. Has that been your experience as well?
Absolutely, that's correct. And that's something that we really do need to do everything in our legislative power to halt the ability to halt and prosecute anybody, especially that gets paid for doing it.
Right. Mr. Green, thanks for your testimony. Any questions for the witness? Thank you for being here.
Thank you.
Anyone else wishing to testify on, for, or against Senate Bill 1508? Seeing none, public testimony is closed. Senator Creighton, recognize you to close on the bill or to speak on the bill.
Yeah, could I close briefly?
Please do.
Yes, I just wanted to quickly say for the benefit of the committee, we have examples we can provide to your office of 100 prosecutions that have led to convictions for voter fraud in this state over the past 15 years. And those are just the examples that we have pulled to use as examples. Texas has seen 4 elections overturned due to fraud in the last 6 years in 2 different counties, 1 different city, and in the Woodlands where I'm from. So we've made reference to the 508 open election fraud counts being investigated in Texas and over 200 cases. I would just ask the committee which of any of those examples does not rise to the level of us giving our state's attorney the priority, the direction, the resources, and the responsibility to make sure that all Texans are protected in the integrity of their elections. Thank you, Mr. Chairman and members.
Senator Creighton, thank you. Well said. This time, Senate Bill 1508 will be left pending at this time. And as the Senate is set to come in session shortly, and some work has to be done to do that, the Senate Committee on State Affairs in a moment is going to recess and will be coming back after the Senate adjourns today. And so the Senate Committee on State Affairs stands in recess until 3 o'clock or adjournment of the Senate. Thank you. Good afternoon.